petition. Appeal was admitted. The stay was not, so we need it to the stay, Lordship. So can it be on tomorrow, Lordship? Or
Tomorrow. One
for orders, all are for orders. Another is, Lordship, we are going to withdraw this case appeal. So tomorrow. And another one, Lordship, we were asked to take newspaper publication, but we have found that the respondent is appearing. So we need a clarification on that. That's hello, obliged.
May I please, Lordship? We have filed an CRPIO today, Lordship, for listing tomorrow, Lordship. Urgency is this, Lordship. The next date fix is on 19th. So for motion, Lordship, tomorrow.
20, Lordship. Tomorrow we've already given 3 cases.
Lordship, what time? 19 is fixed for the next date, Lordship.
Who is responsible
Lordship, I am
for delayed filing?
delayed filing, Lordship. What had happened? The petitioner is a senior citizen. He old age, Lordship. That's why he could not come. Today we have filed, Lordship. Already filed, Lordship. Tomorrow,
Is there any
My-
provision for special treatment for senior citizen?
Lordship, that's why. Yes,
Is it provided?
Lordship.
Okay, when?
20. Friday.
But the next date is fixed on 19, Lordship. That's why.
Okay, tomorrow we'll try as last item.
Lordship.
Yes.
May I please, Lordship, I beg to mention for listing on RFA, Lordship for withdrawal. Tomorrow,
Where?
Lordship. Tomorrow. Withdrawal,
Tomorrow.
Lordship.
All right.
Yes.
My lord, I like to mention item number 5, my lord. This is the criminal appeal, my lord, part hurt, my lord. The matter may be taken up at 2, my lord. I have already informed the petitioner side, appellant side also, my lord.
Okay.
At 2, my lord.
Can it
Okay.
be?
Why at two?
My lord, P. Borthakur will argue the matter, my lord. He is in the Andhra court, my lord. He will also go through it. He will have to go through it. my lord.
Yes.
Okay.
Lordship, prayer for a listing, Lordship, a matrimonial appeal, Lordship, for admission, Lordship, Monday.
Monday. When?
Monday.
Next Monday.
May I please, your Lordship, I beg to mention one CRPIO from listing on Thursday, Lordship. It was
On
last-
Thursday.
Yes, Lordship. It was last posted last year, Lordship, on June.
After vacation, Lordship. Last year listed.
Lordship, there is an urgency. Thursday or Friday.
Okay, Friday.
Okay.
May I please, Lordship? Lordship, I beg to mention for listing in IA in RSA manner. Can be 26th manner. I know, 26th. Must.
May it please, Your Lordship. I'm mentioning a substitution application, Lord. Your Lordship was pleased to direct the registry to list after filing of Wakalatnama. On 3rd, we have filed, my lord. It has not been listed. Can be taken on Friday, my lord. Friday or Monday, my lord.
Monday.
Monday.
23rd.
May I please, Lordship, pair for listing a MSc appeal, Lordship, thinks that this appeal was listed on January, Lordship. Thereafter, it's not listed, even though there is a direction to list this matter after 2 weeks, Lordship. So I'm pairing for that, Lordship.
Under which column?
Order column, Lordship.
Order.
25th. 25th June.
Lord,
May I please, Your Lordship, matter? One MSc appeal, my lord. Matter may kindly be taken up after vacation.
May I please, your
For
Lordship,
hearing?
For hearing. On 22nd July.
may I please, your Lordship, I beg to
22nd
mention MSc appeal for listing for orders. Matter may come up this week or next week.
Take a date from.
On 24th June.
May I please, your Lordship? I beg to mention for IS Civil 1208 of 2016. The application pertains to the continuation of delay in preferring MSc. Kindly the matter may be listed as earliest.
When?
26. 26.
Okay.
May it please,
Yes.
Your Lordship, item number 9. I pray for an adjournment with the consent of the other side matter.
Mr. M. Dutta, learned counsel for the respondent number 1 with consent from the other side. This for listing the matter. When?
Immediately after
After
vacation.
vacation.
Obliged.
Item.
My lord, in regard to item 4, my lord, can your lordship take it 2 p.m.
After?
at 2 p.m.
Today?
Yes, today.
You have already fixed another matter,
number?
criminal appeal at 2
At
p.m.
2 p.m. Then your
Yes, yes. Huh?
criminal matter is fixed.
Oh, that will, I think that will take time.
So take it next day.
Next week.
Thursday?
Thursday.
Well,
Okay, as agreed by learned advocates of both sides, recess shall list the matter on Thursday.
of life.
19th. Item from daily list for admission, item 1, Parthad matter.
May it please your lordship. Before I start, lordship, I think in the file, the rejoinder affidavit which I filed is not on the record,
Rejoinder affidavit,
which I have filed against the affidavit in opposition
when you have filed,
yesterday, your lordship. So that,
it is not available on the record. We'll call for it
yes, please, yes.
later on.
Yes.
Item 2 for orders.
Your lordship.
Yes,
Lordship, in this case, I was directed to take steps on respondent number 3, 5, and 6.
respondent number 3 and 6.
3, 5, and 6. Lordship, may kindly see
3, 5, and 6.
order dated 2/1/2023, Lordship.
Order dated?
2/1/2023.
Yes.
Earlier counsel has already expired, Lordship, and we are newly engaged counsel. So I may be allowed to take steps, Lordship.
You are newly engaged.
Lordship. After
Mr.
R. Sharma, Lordship.
R. Sharma, learned counsel for the appellant.
Lordship.
Then Mr.
D. Bora on behalf of Mr. H. Das, correspondent number 1.
D. Borua, learned counsel appearing on behalf of Mr. H. Das, learned counsel for the respondent number
1.
Respondent number 1. Mr. Sharma, learned counsel for the appellant, submits that he has been newly engaged here in this case, and he may be granted some time to take step upon respondent number 3, 5, and 6 pursuant to order of this court dated 2/1/2023. Accordingly, it is provided that the pair is accordingly allowed. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Lordship.
Item 3,
May I please, lordship. My lord, this case, my lord, the appeal has already been admitted, lordship. The IE was not disposed of in that case, which was issued, my lord.
This ISO stay.
My lord, yes, lord. My lord, I am in possession, lordship. My lord, decree is declaring that capital interest and my lord.
Whether execution proceeding was started.
Yes, lordship.
When?
My lord, the date was on, my last date was on my 13th this month, lordship. My lord, I
13th
filed
of this
affidavit,
month.
lordship, additional affidavit, lordship.
Additional affidavit.
Lost.
When did you file?
It was filed on lordship 9/6/2025. Lordship. It was tagged with the record, lordship.
Mr. Alam, any objection?
No, my lord.
No.
But my lord, in this case, my lord, in the memo of appeal, respondent number 2 have been impleted and respondent number 5, my lord. Respondent number 2 had already died, my lord. There is no substitution.
My lord, that is not, my lord, that is during the pendency of the, my lord, appeal, lordship before. Lord, that is another substantial question of law. That was.
Okay. Heard Mr. M. Ahmed, M.A. Ahmed, learned counsel for the applicant. And also heard Mr. Alam, learned counsel for the respondent number.
Respondent number 1, 3, and 5.
1, 3, and 5.
5.
1,
No, 1, 3, and
5.
4. 1, 3, and 4, my lord.
1, 3, and 4. This application under section 151, read with order 41, rule 5 of the Code of Civil Procedure is prepared by the applicant. Who is staying execution of the impugned judgment dated 6/11/2024 and the decree dated 8/11/2024 passed in title appeal number 27 of 2023. Passed by the learned civil judge Borpeta.
Civil judge senior division, my lord.
Civil judge senior division Borpeta. By which the judgment and decree dated 3/8/2023 in title suit number 34 of 2019 passed by the learned counsel number 2 Borpeta. Whereby the suit of the respondents struck plaintiffs was dismissed. Mr. Ahmed, learned counsel for the applicant, submits that the applicant herein has prepared one regular second appeal, being RSA number 237 of 2012, and the same has already been admitted for hearing by this court. And in the meantime, the respondent, opposite party herein has filed one execution case. And till disposal of the present appeal, the aforementioned case is required to be stayed. Execution case number 5.
Lordship, 5 of
5 of
2025.
2025. Mr. Alam, learned counsel for the respondent, submits that he has no objection. Whereas taking note of the submission of learned counsel for both the parties and also considering the fact that RSA has already been admitted for hearing and the record has also been called for, this court is inclined to allow this petition. Execution of the impugned judgment dated 16/11/2024 and the decree dated 8/11/2024 in title appeal number 27 of 2023 stands state till disposal of this RSA. In terms of this, I stands disposal.
Obliged, Lordship.
Item 21.
Wait, listen, Your Lordship, we mentioned it because we have some urgency, Lordship. Lordship, the office note dated 13/6/25 shows that respondent 1 filed wakalatnama, 2 has received. 3 and 4 notice not yet received, Lordship. And it says that we have not taken notice under usual process. Lordship, can for 3 and 4, can it be deemed served, Lordship, because the notices were sent by registered post, Lordship? And can the delay be condoned?
One J.K. Kusami appeared for respondent number 1 earlier.
Yes, wakalatnama is filed, Lordship. And 2 also received. 1 is the claim. 1 and 2 are the claimant, Lordship.
Who are 3 and 4?
Owner and driver, Lordship.
Owner and driver. Whether they have contested the proceeding before the tribunal?
Okay, I'll just check. No, they did not, Lordship. Paragraph 3 of the judgment. In
They did
spite
not.
of receipt of notices.
Let us do one thing. Our court master will inform Mr. J.K. Kusami. Correct thing, court number 3.
Appear courier, one of Lordship, he is appearing. His sir has.
Acha, okay.
Your Lordship, that is in your counsel is on next.
He will appear.
Yes, Lordship.
Okay, let him appear. We'll take it up after some time. Let
Yes,
him come.
Lordship.
Yes, Lordship.
Item for stay, item 22.
Your Lordship, this matter may be passed over for time being. Your-
Pardon?
Passed over for time being, Your Lord.
Who will appear?
NN Jha, Your Lordship.
NI?
Jha.
NN Zha. Okay.
For hearing, item number 6.
Yes, you are appearing for Mr. A.K. Gupta.
Yes, Lordship, he is another court, kindly the pass over for time being, Lordship.
I am
What
for
to
the
do?
appellant, Lordship.
Pardon?
I am for the appellant, Lordship. In this case, there was no negligence on the part of the vehicle was a stationary vehicle. And for the voluntary act of the deceased, the accident took place.
But that also arises out of use of the vehicle.
Lordship, if it was filed under section 163A, then it is different thing, Lordship.
Then it is?
Then it is different thing. But claim petition was filed under section 166.
Is it not maintainable?
Yes, yes, Lordship. If it is, Lordship, Supreme Court decision, that decision was for the 92A under the earlier Act 1939, because no fault liability. No fault liability. Then it was not required to prove the negligence, only use of the vehicle. But in the instant case, it was filed under section 166 of the MB Act. Lordship. There are several decisions of the apex also, Lordship, in this point. Yes, Lordship, court can decide the case under section 163A, considering the annual income of the deceased at rupees 40,000.
No, but there are some decisions of the Supreme Court. Even the accident took place while the offending vehicle was in stationary position. Then also this petition under section 166 MBA is held to be maintainable.
Lordship, some judgment, Lordship.
The other day you have referred one judgment, Shivaji Dayano Patel.
I have
He referred.
I
Okay,
have
I have referred.
He referred.
My lord, in this case, my lord, what happened, one oil tanker was going on that met with an accident. And my lord, the oil was spilling from the tanker, my lord. At that time, some persons were collecting the oil. Then explosion took place. Then the court has decided that since that is during the use of the vehicle, because 168 says, my lord, 166, that the accident occurred during use of the vehicle.
Under which provision that petition was filed, 166 or 163A?
92A.
My lord, it was under the old act, my lord.
Old
That was
Act
92A, my lord.
92A.
92A, that is Lordship 140.
That is corresponding to 163.
Now it is 163A.
But the wordings are same, my lord, because 166 also says, my lord, that is during the use of the vehicle. And in this case also, my lord, the court has held that there is contributory negligence on the part of the deceased. So that's why only the 50% award is given to the deceased man.
In this case?
Yes, my lord.
Present case?
Yes, my lord. The court has held there is contributory negligence on the part of the deceased, because what happened, my lord, the vehicle in question, my lord, it was there is some mechanical defect, my lord. The vehicle was standing on a jack, my lord. At that time, some mechanics were also there. This person, he entered inside just to help the mechanics, and he have hammered something, and ultimately the vehicle collapsed on him, my lord.
So according to you, this section 166 applicable or 163A applicable?
My lord, this claim application is filed under 166 because 163A, my lord, lordship knows, my lord, up to there is a cap of income, my lord. So 166 filed because he was the deceased was a forest security guard. And my lord, in this case, my lord, the witnesses were also examined, which who says, my lord, although only except CW2, he says that, my lord, he have seen the accident. Others have only says that, my lord, they have seen the dead body lying below the vehicle, my lord. And my lord, my submission is that, my lord, since the vehicle is involved in the accident, so it is during the use of the vehicle, my lord. And already court held that contributing negligence part that I have not challenged, my lord.
So you have not challenged it?
Not challenged, my lord. So contributory negligence, we have accepting that he ought to, but he went to help the persons, my lord.
So what is the quantum?
Quantum, my lord. The total award was 18,47,476. Then it was 50%, my lord, 9,23,738. Because since contributory negligence is there, that's why the court directed to pay only 50% of the awarded amount. And my lord, finding with regard to the accident, if lordship may come to my lord, page 16, my lord. My lord, there are two judgments with the appeal memo. One there is some error, my lord. That's why the second order was passed, my lord. If lordship is seeing the judgment, my lord, of the tribunal, then, my lord, the first judgment starts from page 14. Here, my lord, it is up to relevant will be up to 19, my lord. Then apart from that part, my lord, that is wrongly typed, my lord.
Which one?
My lord, the judgment here, my lord, it starts from page 14, first one. Then, my lord, it is up to, my lord, 19 will be relevant here only. Apart from after 19, my lord, there is some error in the judgment. That's why the second order was passed, my lord. And, my lord, with finding with regard to the accident and negligence, my lord.
Mr. What are the grounds?
Ground is lordship that since the case was decided under section 163 of the MB Act, there was no negligence on the part of the driver of the vehicle insured with the company.
166, no driver, no negligence on the part of the driver.
Yes, it's. As per evidence on record that this is voluntarily crawled under a stationary truck. There was no instruction or participation from the driver. So there was no nexus between the vehicle use and the death. And
So
this is
according to you, this petition ought to have been filed under section 163A.
But he filed petition under section 166 of the MBA.
No, your contention is that it ought to have been filed under 163A.
Then it is maintainable. Then it is maintainable. The court can consider the maximum income of the deceased as rupees 40,000. After 1/3 deduction, by using appropriate multiplier, the court can pass the judgment.
Any other point?
Only this one, lordship. I want to submit my 3 judgment, lordship. This is my.
What are those?
This is my written argument, lordship. One is Oriental versus Mina Bharial.
Here, you have mentioned several judgments.
Yes, it.
You have relied upon all those judgments.
Yes, sir. in, let's say, Oriental Insurance Company Limited versus Mina Ferial, let's say kindly see the para 25 and 27. Let's say, in that decision, this court considered the question whether in a claim compensation under the Motor Vehicle Act 1939, proof of negligence was essential to support a claim for compensation. On the facts in that case, their lordship found that the appeal was liable to be dismissed subject to certain direction issued therein, but their lordship, in the light of the fact that the High Court had discussed the law on the question and it was some importance, felt that it is necessary to state the position in law. Noticing that the liability of the owner of the car to compensate the victim in a car accident due to negligent driving of his servant is based on the law of tort, they could discuss the scheme of the Act 1913 and the law of the question. Regarding view of the High Court that it was not necessary to prove negligence, the court held. So, and 33, the reasoning of the two learned judges is unacceptable as it is opposite the basic principle of the owner liability for negligence of his servant and is based on the complex preceding the previous of Chapter 8 of the Act. The High Court zeal for what is considered to be protection of the public good has misled into adopting a course which is nothing short of different. Their lordship also noticed that proof of negligence remained the consent to recover compensation. Their lordship concluded by saying, in the matter case, we conclude by saying that the view of the learned judge of the High Court has no support in the hold that the proof of negligence is necessary before the owner of the insurance could be held to be liable for permanent compensation in a motor accident claim case. Then, para 27. We think that the law laid down in Minumeta versus Balakrishna Ramakrishna was accepted by the legislature while enacting the Motor Vehicle Act 1988 by introducing Section 163 of the Act, providing for payment of compensation notwithstanding anything contained in the Act or any other law for the time being imposed that the owner of a motor vehicle or authorized insurer shall be liable to pay in the case death or permanent disability due to accident arising out of the use of the motor vehicle compensation as indicated in the second schedule, the legal heir or the victim, as the case may be, and in the claim made under subsection 1 of Section 163 of the Act, the claimant shall not be required to plead or establish that the death or permanent disability in respect of which the claim has been made was due to any wrongful act or neglect or default of the owner of the vehicle concerned. Therefore, the victim of an accident or his dependent have an option either to proceed under Section 166 of the Act or under Section 163 of the Act. Once they approach the tribunal under Section 160 of the Act, they have necessary to take upon themselves the burden of establishing the negligence of the driver or the owner of the vehicle concerned. But if they proceed under Section 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victim or his dependent to establish any negligence or default on the part of the owner of the vehicle or the driver of the vehicle. So it is clearly applicable in this case, Lordship.
You have any other point?
Only on this point, only this point, Lordship.
Only this point. Yes, Mr. Gupta.
My lord, may I come to the judgment, my lord, page 16, my lord. The finding of the tribunal with regard to the accident, my lord.
Page number 16.
Relevant, I am reading the relevant portion, my lord. It starts from page 16.
Yes.
I'm reading the, my lord, from the second last paragraph, my lord. I have carefully perused the, lordship has got it, my lord. I'm reading from the second last paragraph, my lord. I have carefully perused the entire materials brought on record, heard submissions made by the learned counsels for the parties. All the issues are taken up together for the sake of brevity. While reiterating the avertments made in the claim petition, PW1 has in her evidence stated that her husband died on the spot on 5/3/2009 when the driver of truck number so-and-so hit her husband near Saridwar Bazaar over Mansari River while her husband was proceeding on foot. In her cross-examination, she admitted that she had not seen the accident. She denied the suggestion put forward by the learned counsel for OP number 1 and OP number 2 that the accident occurred because of the negligence of her husband. In support of her oral evidence, PW1 has proved the accident information report as Exhibit 1, postmortem report as Exhibit 2, certificate from police Exhibit 3, salary certificate Exhibit 4, death certificate as Exhibit 5, identity card issued by the Department of Forest Exhibit 6. PW2, Sri Ranjit Das has stated that the claimant's husband died on 5/3/2009. He has stated that about 3:45 p.m., he along with PW3 was proceeding from Bhalukpung side to Balipara on a motorcycle when they saw the truck number so-and-so hit the claimant's husband from the back. In cross-examination, he admitted that he saw the claimant's husband, Vikas Jyoti locker, lying below the truck and part of the body was placed beneath that truck. PW3, the Amlesh Saikia corroborated PW2. In his cross-examination, he admitted that he had not witnessed the accident, but he saw the dead body of the claimant's husband lying below the truck. The OP number 1 and 2 filed their evidence on affidavit. Both have reiterated that the accident did not occur because of the negligence of the driver of the truck number so-and-so, but occurred because of the negligence of the claimant's husband himself. It has been stated that the said truck had suffered a breakdown, and on being so informed, OP number 1 brought a mechanic to repair the truck. And when the truck was standing on jacks, the claimant's husband slipped below the truck and hit it with a hammer, because of which one of the jack fell down and the deceased died. In cross-examination, OP number 1, DW1 stated that he was the registered owner of the truck number so-and-so. DW1 denied the suggestion that the truck broke down after hitting the claimant's husband. DW1, while being cross-examined by the learned counsel for the insurer company, stated that he was present at the spot at the time of accident and that he has witnessed the occurrence. OP number 2, DW2 in his cross-examination stated that on the relevant date, he was the driver of the truck number so-and-so. He stated that the owner reached the spot after he informed him about the accident and that the police came to the spot before the owner of the truck reached the spot. He admitted that he had not written in his affidavit that he prevented the husband of the claimant from going below the truck. DW1 further stated that when the claimant's husband slipped below the truck, he, along with 4 laborers and 2 mechanics, were present, whereas the owner of the truck had left the spot to bring a smaller vehicle. The opposite parties also lead evidence of Sri Krishna Mandal DW3 and Sri Ranjit Bandal DW4, both mechanics. Both have corroborated DW1, owner of the truck, and stated that they went to the place of occurrence. On being summoned by DW1 to repair the truck number so-and-so, when they had taken a break from repairing the truck and were having tea, the claimant's husband came and slipped below the truck to see what had happened. Thereafter, the claimant's husband hit the truck from below with a hammer. One of the jack fell down, because of which the truck fell on his body and he died instantly. From the evidence adduced, it is seen that the categorical stand of the opposite party number 1 and opposite party number 2 is that the claimant's husband, having himself slipped below the truck, which was in a stationary condition, the opposite parties are not liable to compensate the claimant. Insofar as the defense evidence is concerned, it is seen that in the written statement, there is no mention of laborers being present in the truck. Moreover, OP number 1 and OP number 2 have stated that the claimant's husband voluntarily went below the truck and at that moment the jack slipped. Contradictions in the depositions of the evidence of DW1 and other witnesses is seen. Inasmuch as DW3 has stated that the owner was not present when the occurrence took place, whereas the owner has stated that he was present at the relevant time. From the defense evidence adduced, it has not been cogently established that either of the witnesses did actually witness the accident, though they have stated in their evidence on affidavit that they had seen the same. Even if the version of the opposite party is taken to be correct, it is incomprehensible as to how a truck standing on 4 jacks slipped. The slipping of the jack indicates the negligence on the part of the opposite parties in not ensuring that the same is installed, erected properly, and in securing the truck from slipping. Moreover, there is nothing on record to show that the defense witnesses seriously attempted to stop the claimant's husband from going below the truck. There was negligence on the part of the defense witnesses in leaving the truck on jack. unguarded and abandoned and leaving the spot to have tea. Responsibility to take due precaution to prevent any person from nearing the broken down truck lay on the shoulders of the OP number 1 and OP number 2, which they have failed to show that they duly filled. Hence, the opposite party number 1 and 2 and their agents DW2 and DW3 are also partly held responsible for the accident which occurred because of the use of the truck. Believing the version of the opposite parties that the claimant's husband voluntarily went below the truck with a view to help, it cannot be said that the claimant's husband desired to commit suicide by going below the truck. However, there being nothing on record to show that claimant's husband was qualified to assist as a mechanic, this tribunal holds that there was in fact some contributory negligence on the part of the claimant's husband in sleeping below the truck, albeit to help the person in trouble. The extent of contributory negligence on the part of the claimant's husband is thus held to be 50%. In the considered view of this tribunal, the accident in hand is squarely covered under the phrase accident arising out of the use of the motor vehicle, and hence the claimant is held entitled to compensation. My lord, this is the finding of the tribunal with regard to the negligence and my lord, the accident.
No, here only discuss about the contributor negligence, where the tribunal has discussed about the negligence on the part of the driver.
My lord, the tribunal has held that, my lord, since the vehicle was unguarded and my lord, the no precautions is taken by the OP number 1 and 2, that are the owner and driver, my lord, to even if the version of the opposite parties are accepted, that the deceased slipped inside the vehicle, but nobody has stopped him, my lord. So on that basis, my lord, the tribunal has held that there is some negligence on the part of the OP number 1 and 2, and my lord held that since the accident occurred during the use of the vehicle, that's why the court held that, my lord, the insurance, the owner, since the owner is liable and the vehicle is insured, therefore the insurance company is liable to pay the compensation, my lord. Because the claimant's version is that, my lord, CW2 and 3 says, my lord, CW2 says that he has saw that the vehicle hit him. And CW3 says, my lord, that while coming, he says he saw that the dead body was lying below the vehicle, my lord. That is the claimant version, my lord.
So there are two judgments.
Yes, my lord, what happened, my lord? Thereafter, my lord, what happened? After page 19, my lord, wrongly, my lord, the judgment of the computation part is of other judgment is typed here, my lord. That's why the second judgment, so in this judgment, I have read up to page 19. That will be relevant for this case, my lord. And my lord, then lordship may come to page number 7, my lord.
There was some clerical mistake that was rectified in the review petition.
If lordship may come to page 7, my lord. It starts from page 7, then from page 8, my lord, this is a review application, my lord.
Okay. But Mr. Kekepat, learned counsel for the appellant, and Mr. K.K. Gupta, learned response. Argument counsel. Judgment. Mr. Gupta, you have prepared this decision.
Yes. Madam Clerk,
In this case, my lord, see, two mixed cases are also shown here. Isn't it? But on last occasion, my lord, condition of delay was made. That has been allowed. So the another petition is, my lord, for setting aside abatement and for substitution. So, my lord, in view of condition of delay, those petitions may also be kindly be allowed, my lord.
It should have come from orders.
The matter is listed for hearing.
This, actually, this should have come for orders,
Order.
but about those without substitution, my lord,
What is the number of that?
ISCB
setting aside of evidence?
ISCB 15000/24 and another ISCB 1502/24.
uh, 1500 is for setting aside abatement.
Delay is gone.
Yes, my lord. IS civil 1501. That was for delay, condition of delay. IS civil 1501. That is for condition of delay.
Okay. Art Mr. Edward Sharma, Lord Head Counsel for the applicant, Mr. S.R. Gogoi,
Correspondent 1 to 5.
for respondent number, respondent opposite party number
1 to
1
5.
to 5. 1 to 5. This application under order 22 rule 3. Read order 22 rule 11 and section 151 of the Code of Civil Procedure referred to the applicant for substitution of legal heirs of respondent number, appellant number 1, namely Abdul Modin. So Sharma Lord Head Counsel for the applicant submits that the applicant has already prepared an application to under section 5 of the Limited Act for condonation of delay of 212 days in filing substitution. The legal heirs of the appellant number 1 and the same has already been allowed by order dated 17/2025 and uh, and uh, there is a requirement for substitution of the legal heirs of appellant number 1. Appellant number 1, namely Mohammed Abdul Matin, Mohammed Usman Ali, Abdul Latif, Abdul Matlib, Sabur Ali, Noor Nahar Khatun, Sabina Yas, Mawasira Begum, Hazira Khatun, as appellant number 1A, 1B, 1C, 1D, 1E, 1F, 1A, 1I in the RSA number 38 of 2012. Mr. Gogoi learned also put a response number 1 submits that is public. Are taking of the submission of learned counsel for the parties and considering the facts that record is interlocutory application allowed. The appointments of legal representative of the appellate number 1 be substituted in place of appellate number 1 in the RSA number 2. But that's all of this. Look at the application. This would see. For setting aside a bit. This introductory application under order 2229. They will section 151 of the Code of Civil. Read with article 121 the acted part of setting aside abatement due to delay of 108 days.
That delay, the 60 days delay, that is regarding the, in the meantime, 60 days, till 60 days, by that, by
260 days.
yes, after 60 days, it starts actually.
In filing application for substitution of legal heirs of the appellate number 1.
It is
90 days.
90 days, then 60 days.
This sort of added concept for the applicant submits that the appellate number 1, namely Abdul Mazid, suffered demise, and in its place his legal heirs are required to be substituted, and also the abatement is required to be set aside in RSA number 38 of 2012. So Google Internet number 151 is of the taking note of the submission Internet of the part also in the back part. The bill of appellant number 1 in RSA number 38 of 2012 stands set aside. It talks about this IS and book. In view of the order passed in I number 1502 of 2024, Mr. Sorma, learned counsel for the appellant, shall file amended clause title within 1 week from today. Then the rest is the leave the matter for hearing on. We'll fix it in the full matter.
After
vacation.
After vacation, let you come up with.
On the 5th of,
Huh?
5th of August.
5th of August. Okay.
5th of.
Oh.
Pending item 21.
Oblige.
Lordship, here in this case, Lordship, I would like to file my response, Lordship, on behalf of the OP1, Lordship, regarding the IL.
This is for condonation of
Lords-
delay of 180 days.
Lordship may pass the appropriate order.
Here, appeal of merit.
Lordship may pass the order, Lordship, as to.
And if Lordship passes it afterwards, the appeal may come next week, Lordship. Maybe he's anxious about the
Next
deposit.
week.
Yes.
If delay is condoned, Lordship, I'll pray that the appeal may come next week because they have a Bakijai proceeding going on. We will need a stay and pay a certain amount. Lordship.
Learning of the learning of for the applicant, sir. JK Goswami, learning of for the respondent number 1. This application under
One and two, sir.
Only one.
Section 5
Wakal
of the
Summa to
Indian
one.
Limitation Act 1960 is referred by the applicant for consideration of delay of 180 days. Within 80 days in filing connected appeal against the judgment and award dated 20th-3/2023 in the case number 5730. Passed by the learned member and the city clerk. What is the ground, madam?
The Lordship ground we have mentioned in from paragraph 3, Lordship. The learned counsel provided the certified copy of the judgment on 17/8/2023 after 150 days. Thereafter, the process started, Lordship. In 4, we have mentioned that. And in 5, we have mentioned that the EA was granted. And in 6, we have mentioned when the check for statutory deposit was received, we filed that.
Yes. Majumdar learned counsel for the applicant submits that there was delay in obtaining the certified copy of the impugned judgment by the counsel engaged by the applicant. And their legal opinion of the counsel of the High Court was obtained. And in the process of delay, has occasion and the same is not intentional, rather it is circumstantial, and yes, the arguable point in the appeal, which are required to be adjudicated on merit. And as such, it's considered to allow this interlocutory application. Mr. Goswami, learned counsel for the respondent number 1 submits that he has no objection in the event of concerning the delay or competent immediate preparing the connected appeal. We are taking note of the submission of learned counsel for both the parties and also taking note of the explanations for coming for the delay. Special explain in paragraph number E and paragraph number E and 4. It's 4 days of the view that the delay of 150 days in filing the connected appeal is sufficiently explained, and therefore this is like concern in terms of above this high instance disposal. In view of the order passed in high numbers, so now the ratio of it to register the appeal and list the same before the court as soon as practical.
No, Lordship, we need a date, 20, Lordship, Friday. The Bakija, Lordship, execution proceeding is going on.
Lordship, copy.
You go to the registry and file an application there
No, that we will do, but Lordship will say ki Friday, Lordship.
as soon as practical.
It won't be practicable, Lordship.
We are not getting the copy of the appeal, Lordship.
Oh, we'll give that, no issue with that.
Mr.
Give me
Goswami,
the
learned
number.
counsel for the respondent number 1 submits that he has not been provided with a copy of the memo of appeal. Ms. Mozumdar undertakes to furnish a copy of the memo of appeal to Mr. Goswami during the course of the day.
No, Lordship, I do not have, and I'm today lots of
by
hearing.
tomorrow.
I'll give by tomorrow.
By tomorrow.
Give your right your number.
Item 8. Item 8 for hearing.
Lordship, matter may be taken adjourned for the day and a date may be fixed. We have taken consent of the petitioner.
Sir, your good name?
A.S. Chaudhary.
Learned counsel with consent of the other side. Price for adjournment of the matter for the day. They are allowed, the matter stands over for the day.
Item 10.
May I please, your lordship? Your lordship, this is the appeal filed by the claimant for enhancement as well as modification.
But who is the respondent?
Respondent, your lordship, on the last occasion also, I took, I requested the court to post the matter because on that day also they were absent.
But in absence of the respondent, would it be proper to hear the matter? Well, the name of some counsel has been reflected in
The cause list.
Pardon?
Reflected in the cause list, I dash.
I does. Obey. He will try to contact her after some time.
Yes, your lord.
Item 11. Item 11. Wait, please, your lordship. But in this case, the main ground for filing the appeal was that involvement of vehicle was lordship, probably lordship doubtful. Lordship, in this case, the government was asked to bring they have come with the records, lordship. Police. They have come with a police record, lordship. Records of police station. Lordship, what had happened in this case? Initially, the police had gone to the spot. And they seized the vehicle which is numbered as 4510. But subsequently, lordship, another vehicle, a charge sheet has been filed against another vehicle which is 0349. And the inspector, lordship, who had come before the tribunal, he initially, lordship, stated these facts, that he had gone to the spot and seized this vehicle. The same person, same officer subsequently said that was it that vehicle number 349 was it?
Whether all the parties are available in the court today?
No, sir.
What Mr. M. Khan appears or?
No, sir, M. Khan
today?
Junior is here, he is in some another court.
Are you ready to? He is ready to argue the matter. Ready? Should we proceed or?
No, he looked.
Let him come wait for some.
Yes, lordship. Item 12.
Meet Mr. Lordship. Lordship, I'm appearing on behalf of Mr. N. Deca. And I've been instructed to take an adjournment because he wants to file an IA because some development has happened. What I'm told is similar, it's a RERA appeal, similar villa, similar size villa, GMDA has measured and found out to be some additional spaces. So, which is contradictory. So we want to bring that on record. An IA may be allowed. That's why we see.
At this stage, we are at the hearing stage, my lord. It has come from the appellate tribunal under RERA Act. First, the member has decided in one way. They have preferred an appeal. In the appeal, there is a direction because the issue is very simple, my lord. They have constructed and we have paid 90% amount. At that stage, they say that see, we have constructed additionally some structures beyond the area mentioned in the agreement. Then the appellate court said, you have agreed for a particular area and they are ready to pay the full amount. You have to execute the sale deed, deliver possession, etc., etc. Now they have come before this on the court. Now the issue is slightly different. My learned friend is saying that, see, it's a question of measurement, my lord. What has happened? Before the appellate tribunal by the then Honorable Justice Bhuiyan passed an order that see, measurement was taken of the entire building in the presence of representatives of both the sides. But it has to be converted into built-up area. Now, while converting built-up area, it has been found that they have constructed lesser area. They are saying the manner in which the area has been converted from the square feet to built-up area, that they are disputing. It is a case, it is a dispute arising out of the individual building, this building. If anything has happened in any other building, that will not help here. And there is no question of improving the case by additioning some fresh evidence at this stage. Evidence has been led before the member. Thereafter, there was an appeal. Now we are at the third stage before your lordship. Issue is very simple, man. I have not got the possession. I have not got the possession. I have paid 90% amount. They are saying that you pay excess amount because there was some excess construction. Whereas the persons who has visited the place, they have found that in the terrace, the actual area mentioned in the agreement has not been constructed. And the verification, spot verification was done in the presence of all the sites. In square feet, the area has been mentioned. Now, only the appellate tribunal has taken the view of the conversion to town planner has converted the area in square feet into built up area. Now, my lord, so far as built up area is concerned, initially in the sanction plan, the built up area was mentioned. It is their sanction plan. The present conversion into built up area is in terms of the sanction plan by them. How can they say that that kind of conversion we will not accept? Issue is completely different now. Now the only dispute remains between the parties is whether the conversion of this area from square feet into built up area is correct or not. This has been done in terms of their own sanction plan. In the sanction plan, they have mentioned what will be the meaning of built up area.
To clarify, just to clarify, there are 4 types of villas in this project. My friend owns a D-type villa. Other D-type villas, the sanction plan says that this amount of square feet will be the built up area. That record I want to bring, because all the D-type villas are under one permission, under one NOC.
My lord, we have got our own sanction plan. Our sanction plan mentions the built up area. It is their sanction plan, not my sanction plan.
I'll rely on that same thing.
And in terms of that sanction plan, whatever is considered to be the built up area, your lordship is aware, my lord, there is one area called carpet area in flats, my lord. And there is one called built up area. In the built up area, certain areas like thickness of the wall, that also is included. So that way there is a difference between calculation of built up area and carpet area. So built up area in our case has been determined on the basis of the sanction plan which they have obtained, not we, my lord.
We are not disputing that, my lord. Everything they said we have given them a smaller house. If a sanction plan says X amount should be the area, their allegation is that we have given them a smaller house. What the size ought to have been, we have not given them that house. Similar cases still pending in RERA. GMDA under RERA's jurisdiction has done a verification of that house. It comes up to be more than the sanction plan. It's just that I want to bring that on record. Whether it has any bearing on this case, whether lordship accepts it, it's totally up to your lordship. But just
one document I would like to bring to your lordship notice. Lordship, may kindly pick up the IA.
Mr. Majumdar, you see, the NKS counsel is Mr. Dekar.
N. Dekar.
He is absent today. Will be proper to take up the matter.
That I am not disputing. What I am saying is, my lord, they are trying to file IA in order to introduce some new document at this stage. On that ground, they should not ask for it. On Mr. Dekar's ground, my lord, I will not oppose.
Both the things, both are my grounds.
Okay, we will see. The meantime, let them file their IA.
This will only prolong. My lord, their intention is to prolong the litigation.
The IA is not before us now.
Not before us. They could have filed it in advance, my lord. They had enough time. Today they are asking for time only on the ground that they want to file IA.
Just after reopening. Because next week is going to be a motion day. It's the last week.
No.
It's the DK Bhattacharya,
DK Bhattacharya.
DK Bhattacharya, learned counsel, appearing on behalf of Mr. N. Dekar, learned conducting with concept the other side, plus for the method, immediately after reopening of the vacation, so as to enable the appellant to bring on record some new facts develop subsequently. Where is according to law, it's a matter of fiction.
Lots even shorter deadline. This IA they can file within a week's time. Because from 2020, I have paid 90% of the consideration money.
No, my lord, this court.
I mean, fixing the matter next week. But
let them file it. Let them file it first, then lots will.
My lord, this matter was sent for mediation. They did not come. They did not agree for that. High Court's order was for mediation. He cannot say now that he has paid 90% and we are not giving him possession. Order sheet will say that.
My lord, lots will fix a date before vacation for their filing of the IA matter.
Hearing matter, but they may in the meantime.
No,
notify
for the purpose of filing the IA, my lord. I'm saying Lordship will kindly fix a date for filing the IA within a short time.
Okay, you file it within 1 week.
Yes.
26 this month.
My lord.
26th. No, 26th is Saturday.
No, 26 is
or June for filing. For filing 26 June.
Filing of the IA.
Obliged.
Can it be on 25th, my lord? 26th,
July,
I would say.
25th.
25th.
Just, I keep the track of the case, Rohit.
Pardon?
I'm the appellate for, yes, I just briefing for track of the case, Rohit. Actually, I'm the predecessor, the lane, the defendant is the vendor. Actually, his land is total 3 katha, but I purchased two katha. So is actually the defendant doesn't give the position, 10 lasa, half of the katha. Now I have processing the 1.5 katha. Now I demanding half katha. So the past appeal courts have been he doesn't not allowed to give the position, but actually in the Munship has given the position, all the title and degree and everything. Lordship. Now let's see the annexure 5, Lordship. Annexure 5, page number 87, Lordship. Paragraph 28. Actually, the issue there is in the plain copy. There is the six issue. Actually, the first appellate court have been accepted. 3 issue. Then remaining issue in the position part is not the issue. It's not the appreciate. See, let's see the para number 28. Whether the defendant is liable to evicted from the suit land. The Rana trial court which decided this, the issue the simply held that the defendant is liable to evicted from the suit land as the plaintiff has right and suit land. However, the pursuit of the judgment passed by the learned, the Munship so ensured that the trial court has not decided any issue with whether the defendant deposed the plaintiff from the suit land and months of November 2023, the building, the culture and the structure is in fact of the appellate is appealed the memo.
Mr. Rongwei, you have closed the plaint.
Yes.
Along with his appeal.
Yeah,
Page number.
Page number Annexure A, proceed. Page number. Page number 30.
Yes.
Yes. Actually, Rochip, I read it, actually, the paragraph one, the plaintiff is the bona fide citizen, so para number two, the defendant is not the plaintiff, who is the adjacent neighbor of the plaintiff and also the residing, the law resident, carving law,
You are reading page number
31,
31.
yes.
Okay. Paragraph number?
Paragraph number two, from started, Rochip,
Okay.
yes.
Yes.
The defendant is known to the plaintiff who is the neighbor of the plaintiff and also residing and Norwegian carving along so and so within the jurisdictions of the honorable court. That the plaintiff is rightful, the beneficiary, the owner and the holding and the plot of land measuring the 2 kata is situated at Norwegian to cover by the periodic pata number 9 under Dang number 99 and Beres Nilman Tea State and the Morja Borjan, the Circle Depot carving along district, be it stated that the father and son the measuring an area of some square feet, 5,760 square feet. This is the part of the enclosure by the dependent worship. Actually, at the times of the purchase, he doesn't give the position from at the times of the purchase. The para number 4, that the regard and the authority has also the issued requested the Kacha house and also the revenue pata in favor of the honorable the plaintiff the pretending in the land so and so and so. That is the photograph of that is in the record receipt. The plaintiff the most respectfully the beg to the stated that the plaintiff has been the making the paying payments of the land, the revenue, respect and her above the said the land in the legal the merger has also to acknowledge the receipt of land. The revenue pata so enacted is given. That it was the month of November 2003, the plaintiff was out of station at Kipri, the Nagaland with the husband who is the SI, the Nagaland police, the dependent taking the advantage, the absence of the plaintiff, the illegal to occupy the land measuring and the 1,252 square feet, which is a part of the pata number 9 and Dang number 99. With the village so and so, it doesn't belong to the plaintiff land. On coming back, the station being the sin such the illegal act and dependent the your husband the plaintiff initially the approach and the requested and the defendant to remove the kacha structure from the land of the plaintiff and clear that the plaintiff had land and but there is no the respondent. The plaintiff in this the regard has also the requested and responsible the citizen of area doing the needful and but the defendant the declined the response and the immediately and the responsible to person. Actually, the plaintiff the request to the sovereign time to the defendant and call the leadership all citizen and have been doing the meeting and such, but the defendant doesn't respond and doesn't cooperate to the citizen, all citizen in our village. Proceed. Para number 7, that the plaintiffs have been to fill up with the act of the defendant submitted the application on 27 to the 4th before the settlement officer and Carving Long Depot and praying and demarcation of her the said land, and in this, the regarding the plaintiff, they received the Jamapandi copy and so and so on 25/6/2004 pertaining to her and said land, the wherein the copy of the Jamapandi, the bearing a note and check and the measuring of the land and two katha, the cover and periodic, the pata number 9 and under the dark number 99, the palace name and tea state, the Bolton is diffuse circle proceed. The para number 8. The dependent is the illegal, the bound, and remove the illegal structures who has been the irrigate the land of the plaintiff and vacate the suit land and measuring and 1,252 square feet and schedule of which the plaintiff in the bona fide the rightful to honor the pata holder the cover the periodic pata number 9 and dark number 99 Nirmanti state, it may be the respectful state due to forcefully the occupation of should land by the dependent the honorable Amber the plaintiff is also the suffering the badly in the developing her land and actual the due torn and putting the boundary wall and etc. in her own the land due to the mischief and act and dependent so and so. The plaintiff the furnish here with and the particular the schedule of the should land the pertaining in which in the declared and position in play the plaintiff the before the honorable court. The land of the schedule, the north portion is part of the plaintiff, south portion is dependent land, east portion is the national highway, western portions of the Nirmal Tea State. Param number 10, the plaintiff the respectfully stated that the dependent is no manner has right and entitled the interest of the suit land and measuring 1,252 square feet in the most as the suit land is the part of the land pata number 9 and pata number 99 of the Nilmanti state, the Borjan and Dipu circle, the Karbenglong, Assam, to which stand in the name of the plaintiff. That the rightful the pata holders of the suit land and the declaration of the right and the plaintiff, the position therefore an essential for the end in the interest of the justice. This is the part of the plain proceed.
So, exactly on which that the respondents herein have encroached your plot of land?
Other?
On which day
Yes.
they have encroached your land?
Yes. Actually, in the time is okay. The boundary, I mean, the boundary, the temporary boundary, the stone is the time is stone is 10 that side.
No,
So
no,
the
on
portion,
which day?
yeah, at the time of the purchase. Then up in the years of 2003, the plaintiff is she is there out of session because of his husband posting at Kipri. The time he has to be leave the station. That is why he left after the one year he come back. She come back. The time the positions totally changed. That is why he called the settlement department for demarcation, Lordship. The settlement department, actually, I'm not find this.
In which month, in which year you came to know about the illegal occupation?
Yeah, the within 2003, Lordship.
In 2003.
2003.
In which part of your plan do you have mentioned it?
Here, Lordship. Paragraph C, paragraph 6, page number 32.
Where is the date?
That is November 3, I think. Now, actually, month November, actually, he cannot remember. She cannot remember date. That's it. November 2003. Actually, it's not mentioned in the month, the date. That's it. Actually, the time she was and posting, I mean, her husband is posting in Capri, but it's difficult to come back and here. So she have to stay with her. Actually, here paragraph 6 is clearly stated that it was the month of November 2003, the which and the plaintiff was out of station in Kipri, Nagaland with her husband, who is a SI of Nagaland police. The defendant taking advantage of the absence of the plaintiff has illegally occupies the land measuring 1,252 square feet, is a part of the Pata number 9 or Dag number 99 of the village Nirman Tea State at Laudijan, Karbenglong, Assam, belong to so. It's clearly stated in paragraph 6.
Yes.
Now,
Come to
actually,
written statement.
yeah, now actually, in the written statement stated there, written statement, the page number,
37.
yes, 37. Actually, written statement stated that the para number 3, he already emitted receipt. He already emitted, actually, it is fact that the plaintiff has purchased 2 katha of land from the defendant. The boundary number, Siri SG, so boundary is also given clearly. He already emitted 2 katha. I'm not demanding access land, Lordship. Actually, I just demanding only 2 katha only, not access land. He already emitted, Lordship. Then paragraph, see, the para number 5, 6 is also is not comment. Actually, paragraph 6, it is the forget the fault, the story, the plaintiff, all the circle, the begin and construct the house and boundary wall on the land and defendant in prison, the of Nagaland, Nagaland police, the making the afraid and defendant, the plaintiff at the period was the sub-inspector of Nagaland, the police, police being the compel and situated the defendant as the file sent. So this is totally wrong. He have been allegation against to the plaintiff lawsuit. There is no boundary. He's saying like that boundary is already constructed. Actually, he demanding a piece of land, but how he going to be the construct the boundary? The case against the registrar so and so, 14 so and so, yeah, the plaintiff surprised the fact that before the court and the case and the orders on so and so, the police, the plaintiff so and so, the remote and the illegal the structure so and so. The original, the case, the record, the kindly be called for to bring fruit before the court and hence the plaintiff is the making history like this. It is also para number 7 is also the fault and minded and so and so story. It also the when those the present the demarcation done the nothing and the mention. So the paragraph 10. the plaintiff fault and trying so and so, the run it, the council and the obtaining the dress and so on, the suit land, the which and in the land and the defendant deal, the after the love of the more than 1 years and the suit was filed, the claiming the illegal position, the right and dependent of land. The para number 11, the honorable court pass the decree and the purchase the land and measuring and 2 katha as per the schedule of the boundary, the defendant, so and so, so and so, in the whole the suit, the defendant know the mention that he was the disposed and deny and the enjoyed of this had the purchased land the measuring 2 katha, the cover and pata number 999. Tag number 99. The para number 12, there is no the course of action. The so and so. Yeah, this is the proceedings of the civil code.
But Mr.
Actually,
Bhumai, in paragraph number 11,
yes.
it is stated that the defendants have no objection if the board passes a decree in respect of the 2 kathas of land.
No, this is wrong. Actually, before filing civil suit, the court can be decide the degree receipt. It's totally wrong. The writing allegation is wrong. Actually, pata is already mediation. Actually, he given the permitted for mediation for 2 katha. It's already recorded the printed land receipt. Actually, before the filing the case, how the honorable court can be make the decree receipt. He's saying like the 11.
No,
the honorable.
this amounts to an admission. On the basis of this admission, the court could have passed the decree.
The honorable court the pass the decree, the purchase and the land measure, the boundary, the defendant the given the W. I'm not objected. Well, this I'm not objected. Honorable court can pass actually regarding the 2 katha. I'm also not claiming the more katha, more land. Only 2 katha only I need. Now this first appeal saying like that, okay, your title is okay, but position should not be given. As for the pata number 9, tag number 99,
So
there is only
what are the issues the trial court had framed?
para number receipt. Issue is page number, this is the first the Munship Code page number 80. Page number 80. Whether there is course of actions for the suit. Number 2, whether the suit is maintainable, it is the present from the manner. Number 3, whether the transfer of the land by defendant to the plaintiff is valid as per the provisions of law. The whether issue number 5, whether the plaintiff has right, title, and interest over the suit land and mentioned in the schedule of the plan. This part is the first appeal is accepted. The part, the issue number 5, whether the defendant is liable to be evicted from the suit land. Then 6, whether the plaintiff is entitled to any other relief. This part is rejected, Lord.
Okay.
That is why I'm come. Actually, now let us come to the substance end
Yes,
of.
Mr. Sendre? Any dispute regarding this para number 11 of your written statement?
Yes, my lord. My written statement is.
Para number, my lord,
11.
11. The Honorable Court passed order on the purchase of land measuring 2 katha. Yes, my lord. I have sold him 2 katha. He is holding, still he is holding. But he is demanding excess land. That is the reason.
No, no,
Because
no.
he has purchased my land. I have here, my lord, in their plan, they have not claimed recovery of khas position. First point. They have not claimed recovery of khas position. Number two, in the plant, they have stated that they have been dispossessed in the year 2003. But in evidence, PW1 herself stated that she was not given position at that time.
Mr. Secretary, you come to this page number 34.
Page number 34.
The pair portion of the plane.
Prayer portion of the plant.
There is a pair for decree for position of the supplant.
Decree for declaration of decree for position, confirmation of position or recovery of position. That is not confirmed. Actually, what happened in paragraph, my lord, in paragraph whole, in paragraph whole, they have stated that in the year 2000, in the paragraph 5, they have stated that in the year November 2003, while I was out of station at Kampi, Nagaland with my husband, the defendant taking under advantage of absence has illegally occupied. But in her evidence, what she has stated, in her evidence during trial, she has stated in cross-examination.
Okay.
In cross-examination, she has stated, when I took the land, no demarcation was made and no position was given to me. My lord, that is contradictory statement, sir. A statement.
There is a income.
My lord.
After 5 minutes.
Suit line at any point of time. The appellate court, first appellate court is decided in issue number 5. My lord, in issue number 5, it is decided whether she was dispossessed from the suit line by the defendant. 87, it is issue number 5, 87, my lord. 87. Page 87. This is the vital issue, my lord.
Yes.
My lord. Issue number 5, whether the defendant is liable to be evicted from the suit line. The learned trial court, while deciding this issue, simply held that the defendant is liable to be evicted from the suit line as the plaintiff has no right over the suit line. However, a perusal of judgment passed by the learned munsif shows that the trial court has not decided any such issue as to whether the defendant disposes the plaintiff from the suit line in the month of December 2003 by building kacha structures there. In fact, the appellant defendant in his appeal memo categorically contended that the trial court had failed to frame a vital issue whether the plaintiff was dispossessed by the defendant from the scheduled land in the month of December 2003. In fact, the main contention of the plaintiff dismissal is that in the month of November 2003, the defendant encroached upon the suit land measuring about 1252 square feet and constructed a structure over the suit land. The plaintiff in his plan, as well as in her examination in chief, reiterated the fact that in the month of November 2003, when she had gone to Nagaland with her husband, who was a SI of Nagaland police, the defendant, taking advantage of their absence, illegally occupied the measuring land constructed by the structure. PW2 and 3, husband of the plaintiff also stated that in the month of so-and-so, defendant taking advantage, absence of illegally occupied the suit land. So, by constructing construction. However, I am of the considered opinion that the evidence of PW plaintiff and her witnesses PW2 and 3 appears back, as it is not specifically stated by them as to what such a structure said been constructed by the defendant over the suit land. It is also not disputed by the plaintiff and her witnesses if the defendant enforced upon the suit land by removing any boundary wall or pillar or fence. In fact, the plaintiff in her cross-examination stated that though she had mentioned the boundary of her land, she has mentioned, but there is no boundary. Therefore, it can be deduced the plaintiff is not sure if the defendant enforced upon the her land. Further, the PW4 Lat Mandal, that is the very in his examination in chief, he categorically stated that in the year 2012, he went to the spot to the 2 Katha land of for demarcation, but he did not make any whisper that he found 1252 square feet of land belonging to the plaintiff enclosed upon by the defendant. He has not found by raising kacha structures. In fact, in his cross-examination, PW4 categorically stated that he does not know of any report regarding 10 less out of the 2 Katha of land. The PW4 being a Lat Mandal would have definitely come to know about the alleged enforcement of 212 square feet, 1252 square feet of land when he had gone to the spot by vision of the land. Measuring citizenship. PW4 is a witness examined by the plaintiff witness, and not defendant. And therefore, there is no reason to disbelieve the PW4. Hence, considering the evidence in its entirety, I am the considered view that the plaintiff has failed to show that the defendant had dispossessed the plaintiff from the suit land by constructing any kacha structure. Thus, situated, I am of the considered view that the learned trial court has erred in concluding the defendant is liable to be evicted from the suit land as the plaintiff. The respondent has failed to prove the fact that the defendant disposes her from the suit land. This issue is accordingly answered in negative and decided against the plaintiff. That is the matter. My lord, in this issue, in the year 2012, they have their document, my lord. In their document, it is stated, they submitted document. In their document, it is 2 katha of land. During demarcation, the revenue authority found 2 katha of land. That is their patta was issued. Accordingly, or patta was issued. They have not raised any objection. This is patta was issued in the year 2012. My lord, Jamandi exhibit 6.
Page number.
Exhibit 6, my lord.
Is it part of the
Record, my lord.
record?
Exhibit 6. It is clear.
Exhibit
6, my lord. Kamini Devi, 2 katha of land. That is their document, my lord.
Project, I'm demanding only 2 katha. I'm not demanding the,
He is
access
holding
land.
the katha, that's why.
Actually, I'm not
No,
filing
but-
at the time, na, Roshi. Actually, 2004, 13/3/2004, the demarcation is done, but I'm not filing this demarcation, the North Sea. Actually, that time commandant already stated, statement already stated that 10 lassa is less than. Actually, the 10 lassa is occupied by the defendant. The Lat Mandal is also saying like that here. Actually, either order is, totally changed. Actually, Landmander is saying like that in the years of 2012, I went to the spot demarcation, the plaintiff talked that the 10 lassa of the land is less than the land. He stated that his statement is given.
You are claiming only 2 kathas of land.
Yes.
And that 2
10
kathas
also only, Your
is
Lordship.
in your position now.
Here, the defendant is position still.
Defendant is still in position.
He's the selling the all, 2 katha, but still the Das Rasa doesn't give the possess still. That's the problem, Lordship. Actually, this is the demarcation. Which I'm not filing it, Lordship.
One periodic patta, another is
If you accept the pata, if you accept the pata, so let us go to the demarcation and find out who is the enclosed land.
Main issue is that I have raised this point also, that whether she was dispossessed from this portion of land, shoot land or not.
That's all right, but you have admitted that you have sold 2 kathas of
Yes,
land to her.
I have admitted,
And
but
you have-
he is also holding. He is claiming more land. That is the
Only 10 laws. So actually the 13
he is
13
claiming
feet,
my lord,
13
more
point
than-
something feet.
I am the owner, my lord. I have given him. He is entitled to get put quota, but he is claiming that my land also. In
No,
addition to
no.
that land,
Your land is only total 10 katha.
he is holding my lord. Another
Your land,
document has yes,
No.
report.
As for document, I need.
My
as for
lord, another
document, I need.
report. Another report is there, my lord. Revenue report is there, my lord. It is
Your
on record, my lord.
your
Revenue report is, my lord, Exhibit 2. Exhibit 2. Exhibit 2.
Yes.
My lord, here this report, this is the report, revenue report. My lord, Sarkari Gaon, east he is holding east 50 feet, west 56 feet, north 120 feet, and south 134 feet. More than the land which he purchased. He purchased 50 feet by 120 feet.
No.
That is the
No. This is Gang.
this is the, my lord, in the gift it itself, it is said, he has purchased 50 feet by 120 feet in the schedule. The gift it.
Proceed. Actually,
50
his
feet by
pata land, actually, if you 150, 120, there is no land, there is the Nilmanti state. Can you sold the Nilmanti state land?
You 50.
No, can you sold the Nilmanti
No,
state land?
It is
Proceed.
reported by Gaumboda that he is holding that much of land. What much of land he is holding, that is Gaumboda has specifically stated. In east 50 feet, west 56 feet,
So if you permit,
north 120 feet, south 134 feet. That means he is holding others land also. He is holding others land also. That is not, I am not concerned with that land. I am concerned with my land only. He is holding 50, 56, 120, 150. I have sold him only 50 by 120 square feet.
Proceed.
How he can
Actually,
claim?
the land
More so, my lord,
from
she has
eastern to west.
One by one.
my lord, more so, she has stated in her evidences in chief across that she has not given possession at a time of taking possession. She has stated, I purchased the suit land in the year 1992. The suit land was not fully given possession to us. What fact it is? Suit land was not given possession to us. And subsequently, she is claiming that she was dispossessed by 1252 square feet land. Upon that point, my lord, no issue was framed whether she was dispossessed by that land, portion of land. And now Mandal,
I'm demanding only the pata land only. I'm not demanding actually, I'm demanding pata only. I purchase pata land only. Your Worship.
No, my lord.
So if he wants 50, 60, then that is goes to the Nirman tea stale land. Can you give that? Can you show?
Two patta.
No, no. So
and
two
one-
pata, you're not.
Here, in your gift deed.
No, no.
In your gift deed, it is
No.
mentioned that a plot of land is situated within.
Your
land and
gift deed
village.
is saying like that
This is
more than
tag number
one bigger.
Survey PP 6, measuring area of 1 bigger 3 quarter.
Lord Mandan's already stated that only 3 kata. He claiming more than 1 bigger. That is the problem, Lordship. Actually, he is the
No, I have 2 patta.
witness is saying like that.
Patta and another is
Witness saying like that more than kata, more than the 1 bigger.
PP patta. Periodic.
I don't know periodic pata but I know pata number 9 and dag number 99 only. But I don't know other pata. I
You can-
purchased from pata number 9 only.
You have right to claim
No.
your schedule. As per your schedule. Give it schedule. I am ready to give it. I have given that portion. That two kata area I have given. He is holding, he has made boundary also. So still he is covering the same under boundary. He has put boundary. He is occupying 2 kata land.
Roship, actually, the land mandar already stated that only 3 kata. But actually, this is the demarcation report, but I'm not filing. But the 10 lasa is the less for rented.
Evidence of mandal.
This is the demarcation report, but I'm not filing to the time at the time.
Given by whom?
This is the demarcation report by actually in the years of 13/3/2004. But I'm not filed this document. Actually, so many times the demarcation and done in that time. Actually, the carving long is the DPU. I mean, executive.
If
officer
document
only
is
they are
filed,
conducted.
submitted in trial court.
So
how
where
can
is the demarcation report? We cannot find out. So many times is done in demarcation. Because the time only they come to know that 10 rasa is less.
My lord, Mondal has also stated in his evidence. What
Evidence is also
the
saying
total,
that
my lord,
all the
reading
evidence is
Mondal
saying that
evidence.
he already sorted out the 2 kata, everything is
lord,
agreed. But there is no dispute, Lordship. Actually, I'm demanding only 10 lasa only. Even the plaintiff is defendant is also admitted. I'm not objected for 2 kata.
No. Mondal has stated before court, his deposition is there.
Mondal
The
says-
total plot of land of the defendant was 3 kata. It is in the name of Kamini Devi.
Where
Why,
is that report?
my lord? My lord,
Where is that report?
record, from record, my lord.
Is the exhibit, is it a
Exhibit, not exhibit, that
Not actually PW
official witness, my lord.
PW4
DW?
4 PW4.
PW4, he was.
Okay.
PW4, evidence, my lord. Yes. Yeah. Yeah. The total plot of land of the defendant is 3 kathas. It is in the name of Kamini Devi, wife of censor, 2 kathas as per records. That is as per records in the Chitha copy. The same is recorded in the Jamamandi, which I brought in the court. Exhibit 6 matches with the Jamamandi copy which I brought today. Chitha is survey exhibit 7, Chitha, present dag number 99. In the year 2012, I went to the spot. The demarcation, the plaintiff told that 10 less of land was less than the actual one. On the west side of the suit land, there is Nirmal Spencer land. Plaintiff informed him. He has not demarcated. In cause, I have joined in the ARO office in the year 1980. First, there is demarcation of the land, then there is a mutation, and then potla is issued. My lord, potla was issued, mutation was done. That is, which is the procedure. The Jamandi copy is issued after following process is followed. Jamandi copy was in the year 2012. That is issued following process. It is fact that as per Jamandi copy, the plaintiff has 2 katha of land in the number 29. As per government presumption possession 2 katha of land. As per the document, the plaintiff is in possession of 2 katha of land.
Yes,
She was
sir.
never dispossessed, my lord.
Sir Rockmay,
My lord.
Sir Rockmay, you
Yes.
see this evidence of the PW4,
Yes.
the survey mandal,
What?
page number 32.
Yes.
In the
Page number?
page number 32. Internal page number 3.
Page number 32. 8.
Not the memo of appeal, but it is the evidence. Evidence of PW4.
Yes, yes, yes.
You come to this cross part.
The close was in the years of 2020, 2012, I went to the spot and demarcation. The plaintiff talked the so and so, 10 rasa plaintiff tell to the mandal. The 10 rasa of land.
This last part of his cross-examination.
Yes.
As
Last
per
part.
the document, the plaintiff is in possession of 2 kathas of land.
Which one?
Last part of cross-examination.
Zone cross examination part, Dorset.
Cross-examination part of PW4.
Which last part?
Yeah, as per document.
Yes, for document.
This is missing.
No missing. Not missing. No missing. Yes, for document, the plaintiff is in the position of two.
It is not a fact.
Not in fact, yeah.
It is not a
Proceed.
fact.
It is not a fact. As for the Jamapandi copy, this is the submission for the defendant lawyer.
That is after police stop.
Yes, yes. No, it is
It is a fact.
It
that
is
has-
fact that
Yes, fact.
the Jamapandi copy, the plaintiff, the 2 katha land is the tag number 99 as per the document, the plaintiff in the position, the 2 katha of land. This is the documentary position, Lordship. The physical position is not mentioned, Lordship. Document is okay. Document is okay, Lordship. The physical position still remain.
Mr. Rockmay, this
Yes.
court has to decide the appeal on the basis of documents placed before it. And this is the evidence of the official witness. He is a lot not all of that area.
Yeah. Lordship, here the physical position is not mentioned. This is documentary position, Lordship.
As per document, you are in position of the
Yeah.
state block of land. Anyway, you complete your argument. You come to the substantial question of law.
Yes. Page number. Page number 18, Lordship.
Yes.
Whether first the appellate court herein after the referred to as the civil judge senior division, the Deepu Karbenglong, the was right reversing the issue number 5 when the finding of the Ranet Munship civil judge junior division Deepu the Karbenglong of the issue number 1 to 4 have been confirmed as the issue number 5 is subject to the finding issue number 1 to 4. Proceed. This is the issue number substance of law. Actually, if the issue number 1 to 4 is followed, then accepted, then automatically 5, 6 is also should be the follow, Rosie. Then number 2, substance, the question of law number 2, whether the purchase of the immovable property is entitled to the degree for possession when the sale has been confirmed and also emitted by the vendor, but the vendor have found in to be the possession. That means the vendor actually still as per the written statement and everything, he have been accepted. So as per the law, then he going to be see whether the purchases the immobile property is entitled to the degree of the possession when the sale has been confirmed and also the emitted by the vendor, but the vendor have been found to be possession. Then number 3, whether the first appellate court was right in the holding that there is no the player of the recovery of the position when there is the player of the degree, the positions of the suit land in the plane. Proceed.
Sir Rangmai, you see, all these questions are based on fact. There appears to be no question of law, not to speak of substantial question of law. So sitting in second appeal, this court cannot go into the facts. This court has to decide the appeal only on the question of law, substantial question of law.
Which one? Part 2. Substantial law number 2.
All these 3 questions are not substantial question of law. It appears to be the question of facts.
Yes, yes.
So sitting in second appeal, this court cannot go into the facts.
Right. Actually, Lordship, actually in the plane is also, I already the player, see, let us see the plane page number. Page number 30, Lordship.
1-3.
Yeah, page number 30.
Yeah.
Should for the declarations of the plaintiff right and part of the position of land. I play actually the first appeal, the judgment saying like that you are not play the position. That's the problem, Lordship. This I play in the prayer portion, Lordship.
Okay. Mr. Secretary, anything to submit?
Well, the question of fact is a fact. Question of fact totally substantial question of law is not there because it is already decided. My lord, issue number fifth. What is the issue number 5? That was wrongly decided. That is the fact. Actually, I have raised a point before the first appellate court to frame an issue as to whether this was in the year 2003 or not. That first appellate court has not taken into consideration because she has stated in the year 2012 the Jamamandi was issued. In the Jamamandi, two Katha of land is stated. Jamamandi Jamamandi was issued after verification of the spot, field verification. Jamamandi was issued. In the Jamamandi, 2 Katha of land. Revenue authority has found 2 Katha of land is in possession of Tabini Devi. Again, the Mandal himself stated that she is in possession of 2 Katha of land. That's why the first appellate court did not taking in consideration that this issue is required. And the matter is
Also, may I request if now the question is that he is in the title, there is no the objective. Now the question is that I'm saying like that position he is already given, but position is still 10 rasa is left. But so Honorable Court kindly they give the demarcation before the order receive. That is better.
Pardon?
Before the order, then if possible to direct it for demarcation.
No.
Second,
We have to decide only the substantial question of law.
Right.
I am not disputing that I have not given to Katha of land. I have given him 2 Katha of land. He is holding. She is holding still.
Okay. Heard Mr. Rongmei, learned
And
for the appellant, that Mr. Secretary for the response. Argument concluded, judgment reserved.
Items 14 and 15.
I mean, item number 15, Lordship. Actually, in this case, we are not being provided with the copy of memo appeal. If Lordship may look at our last order, okay, we are directed to provide, so we cannot do the hearing to the Lordship.
Copy.
In item number 15. Yes. No idea.
So Secretary, there was direction of this.
It was out of mind, my lord, and they did not ask for also, my lord. That is problem. Otherwise, I was supposed to give the copy, and they could contact me otherwise. I'm very sorry, my lord. Otherwise, any other day, my lord, if it is so, my lord.
When? Thursday?
Yes. Next Thursday, lordship.
Next Thursday, cannot be possible. Immediately after reopening. Motion, they will motion. Those resting in occupy next week as motion day. Before vacation.
After tomorrow.
After vacation, immediately after reopening.
Immediately after European Lordship.
It's my hard luck, my lord. Otherwise.
Heard Mr. Secretary, Lord, at council for the appellant in item number 15. And Mr. Sorma for respondent number?
Respondent Lordship, sole respondent, insurance company.
For respondent. In both the matter, you were respondent.
No, Lordship, I am in 15. I am in-
Mr. Sharma submits that though there was a direction of this court in the order dated 21/5/2025, he has not been furnished with that copy of memo of appeal. Mr. Secretary, learned counsel for the appellant undertakes to furnish a copy of the memo of appeal to Mr. Sharma during the course of the day. Today itself, you have to furnish it.
Lordship.
This is a list of matter on 22nd July.
কি বার পড়ে এগুলো? মঙ্গলবার না? Otherwise, the issue is very small. My lord. Order 41,
right, I'm
Rule
reading
27, my lord, on remanding back the matter, my lord.
In MSc appeal number 28 of 2008, 14, item number 14, heard Mr.
Can it be-
Secretary, learned counsel for the appellant, and also heard Madam Mormons for respondent number 1.
Can it be said to be further hearing, my lord? Otherwise, my lord, so further hearing, lordship, may fix on 22nd. On,
Please support the matters as further
yes,
on 22nd.
lordship.
Pending item.
I'm extremely sorry, my lord.
Item 11, pending. Just over.
So, Madam, there was a direction to produce the GR record and the general diary.
Yes, Lordship, general diary, Lordship, I have received, Lordship.
You have
So far as Lordship, other charge sheet and case diary is concerned, Lordship, it is lying in the court, Lordship.
In which court?
In the court of Bongaigaon, Lordship.
Bongaigaon.
Yes, Lordship.
These are otherwise not necessary, Lordship, because
On the
my friend has raised a question in the ZDA.
DDNT, I have received, Lordship, entire. This is the volume of the Lordship. 15 numbers of DDNT, Lordship, I have received.
At what instance that GR case is pending?
Yes. Already transcript has been submitted, Lordship.
Trial started?
Yes, on 31/12/2015. Trial started, 2015. Charge sheet has been filed, Lordship.
The record will be
Yes, it is
required
in-
or not?
It is like.
I'm just.
Magistrate Lordship Bongaigaon.
In which court?
Chief Judicial Court Bongaigaon.
Bongaigaon.
Yes.
Let the record come.
Because the issue here is why such a big fundamental difference between the GD entry, which is also a kind of a FIR, and the charge sheet. One vehicle is, police goes to the spot, seizes the vehicle.
That's all right. Therefore, let the record come.
Yes.
Record come.
DDNT Lordship, it is reflected on 7/7/2025.
25 now, 7/7/2015.
And initially the vehicle number.
There is discrepancy in the number of the vehicle.
Yes, please.
In the subsequently, the FIR has been filed Lordship on 18/8/2015.
After 42 days.
The vehicle.
There a different number is given.
Yes. FIR is different vehicle. Earlier first the DDNT the defined vehicle number.
One ZD entry is 7/7/2015.
one vehicle number, and second was 9/7/2015, another vehicle number.
Yes.
After 42
And,
days.
FIR is telling with second GD entry number. Only this much, otherwise criminal courts records may not be necessary. There is a Supreme Court decision also. Only the, my friend.
No, he has taken the plea of fraud.
So GD entry and other documents, this will be enough.
Which
So
one?
for charge sheet and.
No, there is a discrepancy in the first ZD entry and the second ZD entry.
Yes.
So why the two ZD entry came to be registered? Where is the explanation?
That will, on the assumption,
No,
on the
not
very first
assumption.
day.
Mr. Khan, you were not supposed to explain it. It will be explained by Madam Burma.
I was examined, he has explained the situation, why the number has been changed.
But Mr. Goswami learned it for the appellant. Mr. Khan for respondent number 1. Then Madam Burma for respondent number
5.
Respondent number 5. Which Burma submits that he has received the GD and GD.
Yeah.
GD, but she has not received the case diary and the other record. As after investigation, the investigating officer has already submitted search sheet.
Yes.
Being search sheet number 404 dated 31/12/2015. Before the court of learned seemed to resell my state Boyang. Accordingly, it is provided that the SSL call for the scanned copy of the record of GR case number.
PS, kindly look at the PS case number.
No, here is the.
PS case number
675.
675 of 2015.
Yes, sir.
Boyang PS case number 675 of 2015. Along with the case diary, fixing the matter on suggested that
16th July.
the general diary furnished before the court
Date in
says shall
August.
be kept in the
No,
custody.
July, whole month I'll be.
August. 1st August.
Obliged.
Not to May.
Record. No, not record.
The GR case record also, GR, if the GR case has been decided.
Pardon?
If the GR case has been decided, that one.
This number is not available.
Not able, no?
No.
Yes.
GR case number.
GR case 9.
GR record of Boyang PS case number 675 of 2000. The number is not provided here.
5th of August.
5th August.
5th of August.
Well, I'm not. The July month operation.
I'm praying for date was 5th of August. People lawsuit is.
Okay.
Obliged.
Lawsuit, can it be as part of lawsuit? This is a
Okay.
lawsuit.
Let's still keep the matter apart.
Okay. Coming at a 1.
Please, Your Lordship.
Yes.
Lordship, this is a partner matter. Lordship was hearing. Matter pertains to two issues. First issue was that non-payment of salary. Now, subsequently, when the case was pending, by virtue of this court
Salary was a letter on paid.
Yes. Now, my prayer is to that extent where I have submitted judgment of the Supreme Court, where I am eligible for the interest on that.
For
non-payment of salary on the interest part.
interest part.
Yes, interest. My prayer is to that effect. When I filed the petition itself, I have prayed that interest to be provided on the area salary, since salary was not paid. And after coming before this court, they have paid the salary. And to that extent, I am eligible for interest, which the Supreme Court says, yes, deferred payment of salary, petitioner is eligible for interest. Judgment I have delivered and it's on the file, which the Lordship.
citation is.
When did you file?
Lordship citation is 2021-11 SCC 543.
Okay.
State of Andhra Pradesh.
Okay.
And another versus Dina Vahi Lakshmi Kameshwari. Where 11 para, the last occasion Lordship is marked as para 13. If I may read it slowly, Your Lordship. The direction for the payment of the deferred portion of the salaries and pensions is unexceptionable. Salaries are due to the employees of the state for services rendered. Salaries, in other words, constitute the rightful entitlement of the employees and are payable in accordance with law. Likewise, it is well settled that the payment of pension is for years of past service rendered by the pensioners of the state. Pensions are hence a matter of a rightful entitlement recognized by the applicable rules and regulations which govern the service of the employees of the state. The state government has complied with the direction of this court for the payment of the outstanding dues in 2 tranches. Insofar as the interest is concerned, we are of the view that a rate of 12% per annum, which has been fixed by the High Court, should be suitably scaled down. While learned counsel for the respondent submits that the award of interest was on account of the action of the government, which is contrary to law, we are of the view that the payment of interest cannot be used as a means to penalize the state government. This can be marked. There can be no gainsaying the fact that the government which has delayed the payment of salaries and pension should be directed to pay interest at an appropriate rate. We accordingly order and direct that in substitution of the interest rate of 12% per annum, which has been awarded by the High Court, the government of Andhra Pradesh shall pay simple interest computed at 6% per annum on account of deferred salary and pension within a period of 30 days from today. Lordship, I rely this judgment heavily.
Yes, madam, what is your
number 6.
submission?
Lordship, on this, your lordship, on the payment of interest, your lordship, we have no instruction.
You were claiming interest or from who?
The period.
For whose period?
Yes, Your Lordship. The period is for 9/8/18. 9/8/18, 2018 to 31/12/2018.
To 31?
12/2018. Basically, Annexure 6 of my writ petition. Page 29. Annexure 6, page 29. This is the column. Annexure 6, page 29. This is the area salary list.
Page 25 of your petition.
Page 29, Your Lordship. Annexure 6, page 29. 29. This is the topmost area salary of so and so. This is the period with effect from 9/8/18 to December 2018. That is one part of the prayer. Secondly,
So, what is the rate of interest you have claimed for?
that I leave it to your Lordship.
So, in the case referred by you,
Yes, that was
6%.
Yes. Court has Supreme Court has stuck down to 6%. So that is that I can pray.
Any objection, madam?
Lordship, on this, I do not have instruction because we have filed affidavit on the on leave, your lordship. On this, we do not have the instruction.
One instruction is
Why
declared
it was
here.
delayed, your lordship? Why the area amount was not given, why it was delayed? Lordship,
The law is well settled.
lordship.
Pay 6% interest then. From 9/8/2018 till 11/12/2018.
Yes.
Lordship, then your lordship will give me at least,
No.
let
This
me get
matter is pending
instructions, your
since long.
lordship. Because if the fault is on us, your lordship, if we are at fault, that we have to give the interest.
Pardon?
If the area was not paid and the fault lies on the department, your lordship, then person interest will be, lordship justified, your lordship. If there was some other issues, your lordship.
What other issues?
Lordship, that I do not have the instructions, your lordship.
No, you have already filed your
Yes,
affidavit.
Affidavit has been filed only on the, on leave. your lordship.
What instruction is necessary here?
Para 4 very
And
specific, your lordship.
again, you will raise the matter for years together.
Yes. Para 4, they have stated it. Categorically, they have stated para 4 of their reply. Page 50, your lordship.
That during dependency, we had paid the area salary.
To that extent, instruction as such is not necessary. That is because the case has been pending for last so many, they have not filed an affidavit. Only last date they have filed an affidavit. Notice was issued in the year 2023. Subsequently, when this court wanted to know why, then they have paid it. Till 2 years, they were not filing any affidavit, neither they have paid us.
Because even, in fact, your lordship, in the writ petition also, at paragraph 7, it has been stated that, for the reasons best known to the respondents, during that period, the salary was not given, your lordship. The lordship, one chance may be given, your lordship.
No.
Let me get the instruction as to why it was not paid, your lordship.
No. Admittedly, you have not paid the salary to him within the stipulated period.
Yes, your lordship.
Lordship, we had not paid, but
You thereby force him to approach this court
Exactly.
by filing this present petition. You pay 6%, we will pass the order.
And lordship, the second part of the prayer, where lordship in the last occasion, lordship wanted to know in the earned leave section, 235 was noted. What is, it has to be, my prayer was that 250 earned leave I have earned. They have
250?
250 earned,
250 days of.
250 days of earned leave.
And we have given him for 235 days.
235 days.
15 days has been deducted, your lordship, because at paragraph 5, you have stated why it was deducted.
Paragraph 5 of your affidavit.
Of our affidavit, your lordship. Page 51, your lordship.
Yes.
Your lordship, may I read, your lordship? That as regards the claim of the petitioner for releasing of the unutilized earned leave, it is stated that as per the leave statement of the petitioner who retired from service on 31/7/2020, had availed commuted leave for 15 days. As per OM dated 15/6/1995 and Rule 12A of the revised leave rule 1934, a government servant serving in a vacation department shall be entitled to 10 days on leave in lieu of 20 days half pay leave as is admissible under Rule 13A1 of the revised leave rule 1934. Government servant on such leave will cease to earn half pay leave as provided under Rule 13A1. This pertinent to mention that there is no half pay leave for employees serving in vacation department. Thus, commuted leave availed by the petitioner was deducted from the account of half pay leave as per Rule 13C of the Leave Rules 1934, and hence the question for commuted leave does not arise. As such, she is not entitled for granting 15 days leave as commuted leave. And lordship, we have annexed the office memorandum, your lordship.
Page 54, your lordship. That is very important.
It says the type copy.
Yeah, type copy.
Yes.
There, if I may submit, your lordship.
First letter.
Nothing here, now we have here the revised rule was substituted as below your lordship. The government servant serving in a vacation department shall be entitled to 10 days on leave in lieu of 20 days holiday leave as is admissible under Rule 13A1 of the revised rule 1934. Government servant on such leave will cause to earn half pay leave as provided under 13A1. And your lordship, half pay leave for employees serving in vacation department because he was the headmaster of this school, your lordship, and employees serving under the vacation department, they are not entitled to this half pay leave. And that is why his leave was, his commuted leave was deducted from the account of half pay leave, your lordship. And commuted leave is a leave where a government servant is allowed to convert his half pay leave into full pay leave, your lordship. And the petitioner had taken leave on medical grounds.
Yes.
And since he cannot take a half pay leave under the rules, your lordship, that leave was deducted from the account of half pay leave as per Rule 13C of the leave. 1930. So out of the 250 days, 15 days has been adjusted, your lordship. It has been deducted, your lordship.
Okay. Yes, what is your response?
Yes, your lordship. That notification which my learned friend has referred, at page 53 type copy, the very important thing is noted there that this notification will come into effect down below, your lordship. This will come into effect from the date of issue of the notification. So that means we have to take it as 15 June 95, it will come into effect. So my case, your lordship, is that the petitioner hearing, she has joined service in the year 3687. So till 3687, I have submitted also page 38 may be referred, your lordship. Page 38 is the chart.
Page number?
38. It starts from 37. That is the half pay leave column. How it happens. So prior to that, prior to coming of the notification, this was applicable. Page 37. Lordship, I find it convenient. I've got the main copy. That is more convenient for lordship to refer.
Yeah. Okay.
On the first, your lordship, the first page starts from the 95 notification. Subsequently, on the other page, which your lordship will see, that is for the period prior to the notification. Yes, I think I did. This your lordship will see form of leave account, which I have annexed in annexure 9, but this is the original one, Xerox copy. There, your lordship in the first column, itself, lordship will be 15/6/1985. 15/6/1985. That is how the notification date, and from there they have counted that earned leave thing. So there we don't have any dispute. But if your lordship turns the page and see this is the account of the half pay leave. That is counted, that is to be counted from the period when she started office. That is from the day she's joined, 3687 till 14/6/95. The last date. That is very important. I am on that, your lordship. I had already those amount of leave in my hand. And from there, they have given me 15 days commuted leave. So if I had some amount of those period, I had lordship will see in the third column, 4/8 to 18/8, 15 days was given. From there, it was given. From the earlier leave which was accumulated. It is not the case that it can be adjusted from 15/6/95. My service was from 3687 till 14,695. At that period itself, I have accumulated leave. And from there, I have taken committed leave, which was granted to me of 15 days. Subsequently, this explanation, which now they are giving, that by virtue of this notification, it can be adjusted. From there, 15 days can be adjusted. That cannot be taken, Your Lordship, to my humble understanding. Because I have already had that leave. From there, Your Lordship will see 30 days in the top column, 30 days, 19 days, already it was sanctioned. And there 15 days was given from there. The other page. And this started this notification, yes, from Lordship, there, the Lordship will see 30 days, 41 days already given to me, and then below 4/8/14 to 18/8/14, 15 days. It was from there it was deducted. The question of deducting from by virtue of this notification does not arise. So they have done it illegally. My service period is prior to the notification, and admittedly when these leaves is accrued, my leaves were there, and after subsequently the notification has come at 15,695. From there they have calculated this, yes, this shit. From there we can see 250 days. So there that will remain. That cannot be adjusted with the prior leave.
Okay.
That is my.
We'll pass the order.
Deeply obliged. Deeply obliged. I'm grateful.
We'll start result them.
Yeah, I'm deeply obliged. Lordship will keep the chart. The chart Lordship will keep.
You can artist on a Xerox copy. Take
I'll
the
do.
order.
I'll do.
Okay, item number 5, my lord. My lord, 10 years conviction, my lord. Although, my lord, the paper book is also not there, my lord. But, I need some time, my lord. Otherwise,
Why paper book is necessary? This is single bench matter.
10 years conviction, my lord.
Pardon?
10 years conviction, my lord.
Maybe.
Then, my lord, I need some time, my lord, go through the detailed report, my lord. Although earlier.
Your Lordship.
Objection? No.
Your Lordship, objection. Your Lordship.
Heard Ms. S. Nazneen, learned counsel for the appellant, and Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that he may be granted some time to go to the record. There is accordingly allowed. This is a less the matter. For how long the appellant is behind the bar?
Since since judgment 17/12/2020, Your Lordship. It's been 4 years, Your Lordship.
It is made clear that no further sums will be granted to Mr. Borthakur. List the matter on
29.
respondent number 2. Mr. Your good name? Okay. Respondent number 2.
Obliged.
Running item 22.
My lord, here in this case, my lord, I have challenged the order of the, my lord.
So whether both the parties are ready to argue the matter?
Yes, sir.
Ready? Where is the impugn order?
Impugn order, my lord, page 14, my lord.
40.
Sorry, page 99, next are 14. Last.
Yes. Read it?
Yes, my lord. Parties have, in the instant Miss case has been registered on petition number 102623 dated 1/10/3/23 filed by the petitioner degree holder under order 21 rule 106 read with section 151 CPC for restoration of the title execution case number 29/19 dismissed for default filed order dated
9/1/23. I have perused the content of the petition as well as the written objection filed by the opposite party judgment debtor. I have heard the submission advanced by the learned counsel for the parties. Under order, peruse the materials on record, order 21/106 CPC read as under. 106 setting aside the order ex parte, etc. The applicant against whom an order is made under sub-rule 2, rule 105, or the opposite party against whom an order is passed ex parte under sub-rule 3 of that rule or under sub-rule 1 of rule 23 may apply to the court to set aside the order, and if he satisfies the court that there was sufficient cause for non-appearance when the application was called for the hearing, the court shall set aside the order or such terms as to cause, or otherwise as it thinks fit, and shall appoint a day for the further hearing of the application. No order shall be made on the application under sub-rule 1 unless notice of the application has been served on the other party. 3. An application under sub-rule 1 shall be made within 30 days from the date of the order, or where in the case of an ex parte order, the notice was not duly served within 30 days from the date when applicant had knowledge of the order. From the facts narrated in the petition on oath as well as the documents annexed thereto, it transpired that till 3/12/22, petitioner was duly pursuing the case execution proceeding and taking necessary steps. However, on subsequent dates, petitioner remained unrepresented on account of mismatch between the date shown in the court diary and the CIS and the date fixed in the record of title execution case number so and so. In the court diary and CIS, the date was shown as 14/2/23, whereas the date fixed in the case record was 15/12/22. Therefore, this is not a case where petitioner was negligent in the matter. Petitioner was under the bona fide impression that the case was fixed on 14/2/23 and not 15/12/22. On coming to know about the dismissal order dated 9/1/23, on 14/2/23, the petitioner applied necessary certified copies, instructed his counsel to prepare the petition, which was filed on 10/3/23. Under the above section, I am of the opinion that petitioner has shown sufficient cause for her appearance when the application was called on for hearing. As such, I find it justified to allow the petition. The petition is accordingly allowed.
So what wrong with this order?
At that relevant point of time, my lord, when he filed an application for restoration of petition, I filed, my lord, objection petition. That is page 87, my lord. So it will be annexure 11, page 87. But I have to read the short petition, my lord. These are the grounds, my lord. From 3 onwards, I am reading, my lord. Page 87. The petitioner, decree holder, has filed the petition by hiding the actual facts for which title execution case has been dismissed for default by the honorable court. Petitioner has intentionally remained absent in the court so many times by neglecting the order of the honorable court, that the petitioner has failed to establish her case in the court, and there is no question of irreparable loss to the petitioner, and her case was uncontested, dismissed, hide, and order dated 9/1/23. Petitioner remained absent 15/12/22, 23/12/22, 9/1/23 continuously, whereas the petitioner has filed the instant petition.
Mr. Das, going by this order, can it be said that it suffers from any illegality?
But according to me, my lord, as it was, my
Well,
lord.
according to you,
Yes, my lord.
the court has clearly explained that because of mismatch of the date
yes,
in the CIS and the court diary,
yes, my lord,
the applicant could not remain present in the court. Is it not sufficient ground for restoring the case?
This sufficient ground, but but the case was also, my lord, two types of, there was decree, my lord, execution proceeding.
No,
yes,
we will not go into that aspect.
Yes, my lord.
We will only examine the correctness of this order. So going by this order, and given the reason assigned by the learned
court below,
trial court,
Yes,
Can it be said that it suffers from any illegality or perversity? Hmm?
Because my lord of the petitioner also my lord possibly my lord file application and case was at the last stage of the my lord, disposal of the proceeding my lord. At that relevant point in time, they did not could not be able to appear possibly. That's why it was possibly dismissed for default.
Yes, what is your submission?
My submission is also already recorded here because of the mismatch between the court diary SIS dates as well as the date given in the execution petition. We are in the impression that on 14/3/23 the case was fixed. But when we come on 14/3/23, we come to know that is already dismissed default earlier. So immediately thereafter, I have taken steps for filing of the application for restoration of the and accordingly it was restored. And there is a clear provision in order 21/106, your lordships, if any execution proceeding dismissed for default, it can be restored under order 21 rule 106, your lordship. So accordingly that power has been exercised by the learned trial executing court, your lordship. So my humble submission, your lordship, that this is the order which need not require any interference, your lordship. It's a hit case where this petition is dismissed, your lordship, because it is apparent everything written in the order, your lordship. And moreover, your lordships, what I have a degree holder, your lordships. I have to get the fruit of the degree, your lordship. Because of these technicalities, if my education petition goes, your lordships, then, your lordship, I will be barred from getting the fruits of the degree.
Heard Mr. H. Das, learned counsel for the petitioner, and also heard Mr. N. and the learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, read it. Section 151 of the Code of Civil Procedure. No, sir. 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 19/2/2024 passed by the learned civil the senior division Kamrup M. Guwahati in title execution case number 29 of 2019. It is to be noted here that by the impugn order dated so and so passed in Mizje case number 327 of 2023 arising out of title execution case number 29 of 2019, the learned civil judge senior division number 3 Kamrup M. herein after trial court, learned trial court has allowed the restoration petition of the
Executing court. Executing.
pardon?
Executing court. Execution was this.
No, here it has not been mentioned as executing court. Has allowed the restoration petition of the title execution case number 29 of 2019, which was dismissed for default by order dated 19/1/2023 in Mizje case number 327 of 2023 of the respondent herein by allowing condonation petition being Mizje case number 328 of 2023. Mr. Das, learned counsel for the petitioner, submits that in the title execution case number 29 of 2019, the respondent herein, being the decree holder, remain absent on various dates before the learned civil judge senior division number 3 Kamrup M, for which the learned civil judge senior division number 3 has dismissed the said execution proceeding on 9/1/2023. 9/1/23. But later on a petition being filed by the respondent herein, the learned trial court has restored the execution proceeding by the order dated 29/2/2024 without there being any justified ground And as such, Mr. Das submits that the impugned order dated 29/2/2024 warrants interference of this court. Par contra, Mr. Jha, learned counsel for the respondent, submits that the learned civil judge senior division, considering the relevant provision under section 106 no, order 21 rule 106 CPC, and also considering the grounds mentioned in the petition filed by the respondent herein, has restored the execution proceeding to file, and the said order suffers from no infirmity or illegality requiring interference of this court. And accordingly, Mr. Jha has consented to dismiss the petition. But having heard the submission of learned counsel for both the parties, I have carefully gone to the petition, the documents placed on record, and also perused the impugned order dated 29/2/2024, passed by the learned civil judge, senior division number 3, Kamrup M. Guwahati, in major case number 327 of 2023. It appears that the basic facts here in this case are not in dispute. It also not in dispute that in the title execution proceeding number so and so, the respondent herein remain absent. And the reason for absence is duly reflected by the learned trial court, learned civil judge, in the impugned order dated 29/2/2024, by stating that the facts narrated in the petition on oath, as well as documents annexed thereto, it transpires that till 3/12/2022, the petitioner was duly pursuing the execution proceeding and taking necessary step. However, on the subsequent dates, the petitioner remained absent on account of mismatch between the dates shown in the case diary and also in the CIS. And the date fixed in the record of title execution case number 29 of 2019. While the case diary and the CIS reflects the date as 14/2/2023, the case record reveals that the date was fixed on 15/12/2022. And thereafter, the learned trial court has observed, learned civil judge, senior division number 3, has observed that this is not a case where the petitioner was negligent in the matter. And the petitioner was under the bona fide impression that the case was fixed on 14/2/2023, not on 15/12/2022. And on being aware of the dismissal of the execution proceeding by the order dated 9/1/2023 and 14/2/2023, the petitioner applied necessary certified copies and instructed his counsel to prepare the petition file on 10/3/2023. And the petitioner has shown sufficient cause for her non-appearance. And thereafter, the learned court has allowed the petition and restored the execution proceeding number 29 of 2019 to the file. Thus, having examined the impugned order in the light of the facts and circumstances on the record, and also in the light of the relevant provision, that is Order 21 Rule 106 of the Code of Civil Procedure, this court is of the considered opinion that the same suffers from no infirmity or illegality requiring any interference of this court. Accordingly, in this revision petition stands dismissed.
Number 16 and 17.
May I please, Your Lordship? Your Lordship, item number 16, the IA relates to an application which we had filed regarding the violation that has been done by the appellants after the status quo order was passed. And the learned, this honorable court had directed the learned trial court to record the evidence, and the record has been received. Evidence with regard to the violation was recorded before the trial court. Evidence was led and cross-examination was done. Now,
May I please, Your Lordship? That Ayaz Ali, one of the appellant, Your Lordship. I have instruction that he has expired, Your Lordship.
In IA?
In IA also.
In RSA?
RSA, he is for the appellant.
RSA, I am for the appellant.
Okay.
Means what has happened is that suit, I was the plaintiff in the trial court. The suit was decreed in my favor. Their counterclaim was rejected. Thereafter, they filed an appeal. The appeal, our
counterclaim was decreed.
I'm for the plaintiff. So thereafter, they filed the appeal. They were the defendant. Their counterclaim was rejected. My suit was allowed. Thereafter, they filed an appeal. The trial court's order was upheld by the first appellate court, against which, in both the suit as well as the counterclaim, against which they have filed two second appeal. The 158 is with regard to the title suit filed by us as the plaintiff, and RSA 60, I think, that is the counterclaim which they had filed. Now, what had happened at the time when this appeal was admitted, a status quo was granted with regard to both the or judgments, Your Lord. Now, after the stay order status quo was passed, they started encroaching into the suit land and undertaking constructive activities over the same. So we filed an application before this honorable court under Order 39 Rule 2A. This honorable court directed this particular application to be transferred to the learned trial court for recording of evidence and then return the same back to this honorable. So now that particular evidence has been recorded, and the
record has been received by this court?
Pardon, Your Lordship.
Record has been received by this court?
Yes, yes, it is there. In the last occasion, Your Lordship's order is also reflected that the registry has received the order. If the Lordship sees the order of the Lordship.
Order dated 4/4/25.
I ready for hearing. Now you tell me, can we hear the matter?
Because with regard to the violation, Your Lordship, there is.
With regard to that, he has apprised this court at one of the.
He has to now, because it is him to substitute that.
In the main appeal and in the IA, he is a party.
I also he is party. What
Yes,
is
Your
the
Lordship. IA, opposite party number 2.
opposite party number?
2, Fayez Ali.
Samla Beva.
No, Your Lordship. I think it would be Fayez Ali.
Fayez Ali.
Fayez Ali, Lord.
Fayez Ali.
And Lordship, I have seen the record, but I have not found Lordship the lower court record whether has only evidence and
that is the evidence here.
evidence part, Lordship, newly recorded after all the records have been shipped lower court, but this evidence part. Title appeal number 1 of 2019.
Like the
Evidence or affidavit of three witnesses. I could not find it out, Lordship.
D. Okay. On separate file. Over.
Piece he said.
Oh, it's a committee.
There will be three witnesses, Your Lordship. They are Cross and
Chief and Cross.
Like the.
It would be after 13/12/2024.
Mr. Biswas, have you gone through the record?
yes,
I mean,
You have seen it?
I have gone through.
he is saying that it is not, may I be
Yes,
permitted?
yes. You go through it.
Just
And if there is a requirement for implement of the
substitute, he has
Yes,
to
legal,
bring on record the legal heirs of the appellant number 2. And after he gives that, then I may be allowed to substitute in the IA.
In the I also.
Okay. So you first go through the record.
I'll just go through the record. Lord.
Item 18.
Between 18 and 19, they are connected matter against the same preparatory judgment. Therefore. But I am raising a preliminary objection, Your Lordship, the mentality of the second appeal. Because there is no question of law has been framed at all, Your Lordship. These are all
And
facts,
how it is admitted?
Your Lordship, that.
Without framing substantial question of law, how it is admitted?
According to you, they are not substantial question of law. According to you, they are not substantial question, all on facts. Your Lordship will see the question of law. That is a
So that's why the hearing.
substantial. Your Lordship will see page 8.
No, it appears that a substantial question of law has been framed.
Yes.
Very competent by the court.
But Your Lordship, these are not because in terms of the effect for later judgment, this cannot be question of law, Your Lordship.
These are to be argued in the course of hearing.
I'll view the judgment, Your Lordship, if that, Your Lordship. Specifically, there's a
So
question of.
both the matters are ready for hearing.
Yes, Your Lordship.
It's a matter of 2023. 24. Sorry.
Short matter, because these are ancestral property partitioning, Your Lordship. The trial court has given them adverse position in ancestral property, Your Lordship. And the appellate court has set aside everything and given the title to me. And their position to me as.
Okay, start it.
But today I need a little bit accommodation. I'm not fully prepared with the case today, my lord. Any
You
day,
are
my
not
lord.
prepared.
Yes, my lord.
But Mr. Soduri is from Delhi.
I am so sorry. I didn't know. Tomorrow, if possible.
Tomorrow I have no problem. Tomorrow it is day after tomorrow. It will be day after tomorrow.
Day after tomorrow, we will
Maybe as a
try.
part, you will finish it up. Sorry, it don't take much time.
I'm so sorry. I didn't know he is out of.
Okay, we'll try at 2 p.m.
Yes,
Day
sir.
after tomorrow.
Yes, sir. Deeply appreciated.
As agreed by learned advocates of both the parties, recess and release the matter on Thursday at 2 p.m.
Deeply appreciated.
Much only.
19. Item 20.
May I please, Lord? But here is the case regarding
This
temporary.
IA is for what purpose?
IA for
IA was
vacate the stay order.
Vacate the stay order.
There was a stay of the injunction orders, my lord, passed by both the courts below. That was stayed.
Injunction order was stayed by this court.
Yes, my lord. On the first day itself, my lord. Of the stage.
On the first day.
Yes, on the first day itself without hearing.
So is there any bar in
I
staying
was
the-
yes, ma'am. I was heard. Thereafter, honorable court, it was posted for final hearing. Finally, it should be. It will be disposed of. There is an order, ma'am.
when it was stayed?
Lordship, it was stayed on 11/12/2024, my lord. Yes.
On
Lordship, 11/12/2024.
11/12/2024.
Yes.
After hearing the parties, it was stayed. Is there any bar in?
No.
Then you are submitting in such a way that the court has committed grave mistake?
Yes, ma'am.
No.
Huh?
No.
Yes, ma'am. He was good on that aspect. Yes, ma'am.
So IA is filed by you?
Yes.
For vacation of the order?
Stay on.
Stay order. So what is the ground?
My lord, because, my lord, the main title suit still pending, my lord. Here, my lord, is a case, my lord, where, just to give a brief background of this case, my lord, we, the respondents, my lord, we have been in possession of some government khas land in the village of Dalandikash, that is in the district of Darang, my lord. We have been in possession of that land for about 50 years, my lord, almost half a century. And adjacent to the land where we are residing, my lord, there is a school, my lord. The school knows that, my lord. For 50 years, they did not create any problem for us. Suddenly, in the month of November 2022, they start creating troubles for us by saying that this is the school land, you should go on. Being aggrieved, my lord, we filed a writ petition before this Honorable High Court. Honorable High Court directed us to approach the trial court. And we filed a title suit before the learned trial court. Along with the title suit, my lord, we also filed an injunction petition. And that injunction petition, my lord, the learned trial court, after hearing both the parties at length, my lord, passed an ad interim injunction order in our favor, my lord. That can be seen at page number 90 of the CRP. Page number 90. I may kindly only read the last portion of the main order, my lord, page number 98.
Page number?
98.
98.
Yes. May I read, my lord? Para 11 onward, my lord. Thus, considering all the above observations, I am of the opinion that a prima facie case does exist between the two parties and that there are certain rights and liabilities of each party that need to be adjudicated upon and shall be decided at the time of the trial of the main suit. Balance of convenience and irreparable loss. Para 12. The factum of the possession of the suit lands currently being in the hands of the petitioner, that is us, my lord, have not been denied by the opposite parties, who have simply alleged that they were their permissive occupiers only, and as such do not have any right to apply for allotment of plots of land, including in the total land described in the Schedule A of the petition. They had, however, asserted that the suit land is no longer government land, as it had been mutated in favor of the Kuaripukuri High School A in the year 1999. However, the opposite parties have not submitted any documents in support of the contention while the petitioners herein have submitted the photocopies of several documents which shows that different blocks of land described under Schedule A1 to A10 have been under the possession since a long time. Only the nature of the possession over the suit land is under dispute in the main suit. Para 13. The petitioners have brought the present prayer for injunction on the primary ground that the opposite parties had attempted to dispossess them from the Schedule A1 to A10 suit land. They have prayed for relief, stating that the opposite parties are required to be restrained from following through with such plans as it would cause irreparable loss to them if they are forced out of the suit land during the pendency of the trial and before they are able to prove their rights over the state. The opposite parties have denied such allegations of such illegal activities on their part, but have not raised any specific objection against the claim of the petitioners that they are currently in possession of the suit property, which had admittedly handed over in contractual basis for cultivation. It is pertinent to know at this juncture that from the materials placed before me, it appears that the petitioners are currently in possession of the Schedule A1 to A10 suit land, and whether or not their possession is legal is a matter of evidence that shall be considered in the trial of the main suit. In the meantime, I am inclined to agree with the petitioner's submissions that it should have been that they are forced out of the Schedule A1 to A10 suit land during the pendency of the suit without giving them a fair opportunity to prove their claim over it. They shall suffer irreparable loss, as they will lose their stance in the case itself, and such loss cannot be quantified in terms of a specific amount, and as such cannot be adequately compensated later by monetary relief in the form of damage. Moreover, the balance of convenience tilts in favor of the petitioners, as the extent of loss that shall be suffered by them if they are dispossessed of the Schedule A suit land during the pendency of the trial would be far greater as compared to such, if any, suffered by the opposite parties if the situation were left untouched. Furthermore, the primary objective behind granting temporary injunction must always be kept in mind, which is to preserve the subject matter of the suit and maintain its original character in the status quo during the course of the trial and until the rights and liabilities of both parties are ascertained and confirmed. Hence, considering the above observations and for the ends of justice, this court deems it fit to allow the prayer of the petitioners for grant of ad interim temporary injunction till the disposal of the main suit. Now, my lord, this is the trial court's order, my lord, whereby the injunction order was granted in our favor, the respondent plaintiffs. Being aggrieved, my lord, against this order, they preferred an appeal before the learned appellate court. And the learned appellate court dismissed their appeal and upheld the injunction. And the appellate court's order, my lord, is from page 110. It's a very elaborate and extensive order, my lord, where all the law points and evidences have been discussed. My lord. I'm reading from page 120, months. May I read? Para 19, my lord. Now, turning to the facts in hand, I have minutely gone through the impugn order, a bare reading of the order of the learned trial court. It appears that while dealing with the petition for temporary injunction and the objection of the other side, learned trial court has taken up the above three principles in three distinct heads and discussed the facts and law in details and arrived at a finding of existence of prima facie case, balance of convenience, and irreparable loss and injury in favor of the respondent plaintiffs. And at the first sight, there is no infirmity in the order for non-consideration of the golden principles. Para 20, in Dalpat Kumar versus Prahlad Singh, a bench of two judges held that the phrases prima facie case, balance of convenience, irreparable loss are not rhetoric phrases for incantation, but words of wit and elasticity intended to meet myriad situations presented by men's ingenuity in given facts and circumstances, and should always be hedged with sound exercise of judicial discretion to meet the ends of justice. The court would be circumspect before granting the injunction and look to the conduct of the party, the probable injury to either party, and whether the plaintiff could be adequately compensated if injunction is refused. The existence of prima facie case, the right and infraction of the enjoyment of property or the right the condition for the grant of temporary interest. Prima facie case is not to be confused with prima facie title, which has to be established on evidence at the time. This
Okay,
for-
thereafter the first appellate court has
Upheld the injunction.
appellate court has upheld the order of death. And against this order, the civil revision petition.
Yes.
Yes, challenge before the High Court.
Now, my lord, regarding
What are the grounds they were challenging, they were asking for vacating the order?
down by
Yeah.
my lord, ultimately the title suit will decide the rights of the parties.
Hmm.
This injunction order, lord, and there are concurrent findings of the court below. Exercise of revisional powers, be it under 115 CPC or under.
No, this is only interim order, this is not the final order.
Yes. So, my lord, exercise of revisional powers, be it under 115 CPC or under Article 227, my lord, is very minute. They only can be exercised, my lord, if the courts below acted beyond their powers or the courts below went beyond their jurisdiction. My lord. And this is not a case, my lord, that both the courts below went beyond their jurisdiction or there was some kind of procedural flaw. There's nothing. Regarding this, my lord, I would like to place some reliance on some Supreme Court judgments and some High Court judgments, my lord. Your lordship permits me.
No, that law is well settled.
Yes, my
But the grounds which you have cited for vacature of the creditor, that's
because, my lord, the title is still pending. If the injunction order is, my lord, removed, my lord, and during the pendency of the title suit, if I am removed from the suit land, my lord, I am going to suffer an irreparable loss, as stated by the learned appellate court and the trial court, my lord. During the pendency of the trial of this suit, my lord, both the courts below found that the three golden principles that needs to be kept in mind while passing an injunction order, my, that is balance of convenience, irreparable loss, and my lord. So, my lord, taking all these points into consideration, my lord, if I am dispossessed during the pendency of the title, I will suffer irreparable loss. And later on, even in the title suit, if it is found that I am the rightful owner, no amount of any kind of order would not be able to compensate me, because if I am dispossessed from the suit land during the pendency of the title suit, I will be on the road. And therefore, I'm going to suffer irreparable loss. And against concurrent findings of the court below, my lord, revisional powers, my lord, should not be exercised, be it under 115 CPC or Article 227.
no, this RSI is yet to be heard. Not yet disposed of.
CR3, but the main suit is yet to be heard. And it's still pending. my lord.
Yes, that is, it's yet to be disposed of.
Yes, sir.
Uh,
I would like to rely on some judgments, my lord. Even in case of injunction orders, my lord, when both the courts below have passed an injunction order, what is the scope of interference under Article 227 or under 115 CPC? It cannot be interfered unless they point out that the court below went beyond their powers. Even a right or a wrong order cannot be interfered with. All the law points, all the evidences have been discussed by both the court below.
No, that is not correct. Wrong order, why should not be interpreted?
So, that the court below went beyond the jurisdiction. That is the only thing that is, because all the evidences have been discussed by the two fact-finding forums. There cannot be representation of evidence. And if two views are possible, my lord, and if both the courts below have taken one view, then, my lord, the Honorable High Court will not substitute with a different view merely because a different view was possible. That is the law as per the Honorable Supreme Court judgment, my lord. So far in the CRP, they're only discussing about evidences and facts. It is not to be done.
Who is the owner of the land? School.
Yes,
No, my lord, that is yet to be determined, my lord.
Lordship,
That
it's
is still pending.
a public institution. Provincial is school. So it is a corollary to under government. Man. They also admit that it is a government land. And
not-
admittedly, they were engaged in an agriculturist. If this was a disputed plot of land cultivating by the school by engaging some expert agriculturist.
Land belong to the school.
Yes, ma'am. Belong to the school. And my learned friend is,
Is there any document to show that it belongs?
yes, Lord,
only mutation or
Lordship, page Lordship 30,
1330.
30, Lordship.
Yes.
Yes. As per the resolution number 94 of the meeting of the Land Advisory Committee of Udalguri Subdivision held on 31/12/1993, the land measuring 3 bighas 4 kathas 1 lessons of Dag number 83 and 84 of 2 number Kwaribukuri village under Mauja Dolgam and 6 bigha 1 katha 9 lessons of Dag number 44 of village 3 number Golondika under said Mauja. Total 10 bighas 10 lessons has approved in the name of Kwaribukuri City Senior Madrasa. Well, this is the land mutation. And thereafter, circle officer issued a certificate, page 33. Page 33, double three. Issued certificate here. Yes. To whom it may concern. This is to certify that the Kwaribukuri Senior Madrasa is situated under the 2 number Kwaribukuri Gaon of West Dolgaon Mauja Dolgaon Revenue Circle. The 2 number Kwaribukuri fall under the general area of Torong district outside of PTAT area. Schedule, name of the institution, Kwaribukuri Senior Madrasa, Circle Office so Mauja Satsantas, village. Tag number Lordship, land measuring 3 bigha 4 katha, 1 lessons of tag number 83, 84, and 6 bighas 1 katha 9 lessons under tag number 44. Total 10 bigha 10 lessons. This was circle officer certified.
Para 23 and 24, okay, let's put the order.
Let it.
And then my lordship, circle officer also already entered appearance before the learned trial court. They have also filed their written statement, and they are also categorically stated that this land is belong to the school. And lordship, interestingly, before institution this suit, earlier they approached the Honorable High Court with a writ petition. A writ petition was disposed by an order dated 26/2023. Lordship, may kindly peruse page 43, Lordship. Page 43. That totally they suppressed in the title suit. And being a engaged agriculture, now they are today demanding that this land are we have occupying since 50, 60 years. Whereas it is mediated in the year 1993. What kind of pleading they have pleaded before the learned trial court, my lord? The mentality also, what kind of public institution land they are wanted to grab. Nowadays, this dispute is before this honorable court. Lordship, page 43 onwards. Operative page 47. My lord, the last paragraph I am reading, my lord. 47. Insofar as the second prayer of the petitioners in the instant writ petition is concerned, Mr. A.U. Ahmed, learned counsel representing the respondent number 6, has produced a copy of the letter dated so and so, written to the Senior Standing Counsel, Secondary Education Department, Guwahati High Court, by Mrs. Monica Borgohain, SCS in charge, Inspector of Schools, DDC Mongoldev, had memo number such and such, in connection with the instant writ petition, whereby it has been recorded that the land mentioned by the petitioner herein belongs to the Kwaribukuri High School. Accordingly, the second prayer made by the petitioner in this petition appears to be a civil dispute between the parties. In view of the above, this writ petition is hereby disposed of with liberty granted to the petitioner to approach the competent authority for allotment of land under their occupation and also to approach the appropriate forum for resolving the land dispute between them and the respondent number 6 and 7 if so advised. Well, this petition was disposed of, and they are narrated some statement that they're landless, so on, so on. The government is there. Why school land is they particular land they necessary to occupy? Others land, if their genuine grievances there, they ought to have been their grievance being before the authority concerned. And interestingly, in the writ petition was 11 petitioner. Now 8 plaintiffs are before the trial court, and out of 11, others 3 where there is no statement. Why petitioners are changing time to time? What is the intention behind it, Lord? Well,
Do
school
you-
is
do
now
you,
under threat.
Mr. Mahmood, do you have any other document to show that
Yes.
you are the owner of that plot of land?
Yes, my lord.
What documents are you having?
Yes, my lord. I have created photograph of the houses that I have.
No, photographs are not
lord,
the document of title.
Yes, my lord. I have also exhibited my applications that I have submitted under the Basundhara scheme of the Assam government. My lord, the Basundhara scheme of the Assam government, my lord, it has several objectives. One of them being, if a person has been in possession of the government asset for a long period of time, they can apply. But before that, my lord, before they are granted the application, my lord, a field verification is conducted by the lord. Only after that can an application be accepted. That those applications, my lord, may kindly be seen in our IAF.
No, that application would not confer any right upon you.
No, and Basundhara scheme is
And
have to
regarding
go.
them, my lord,
Is
that is one point. Yes, my lord, here I have been in possession of 50 years. They did not, and suddenly in the month of November 2022, they realized this is the school land. What were they doing before that? They're saying the school is given in 1993. Before that,
No, it is their prerogative when they use the land.
my lord, as far as the evidence are concerned, the learned appellate court, my lord, may kindly see reading the order.
No, the suit is still pending there.
Yes, the suit is still pending. For the
CRP is
injunction order,
also
my lord,
pending here.
for the injunction order, my lord, a person does not have to prove his title beyond the state of the doubt, my lord. He just has to show that he has a prima facie case, my lord. In paragraph 23, my lord, again, the learned appellate court discussed, and even in the judgment that happened, if a person is dispossessed from the, my lord, if a person is an encroacher, there is a proper procedure. Rule 10, Rule 18 of the Assam Land and Revenue Manual says that a district commissioner will take the appropriate steps. And district commissioner has been made a party in the title. Then, my lord, the school headmaster cannot tell me to go away from this land. The district commissioner will conduct survey.
Why
Because
why the headmaster could not say? Because the land was allotted to the school. Who will say if the headmaster does not say?
my lord, the school land is different, my lord. It does not belong to them. I have been there 50 years, my lord, since the time of my grandparents. And here, my lord, is bringing.
Where is your document?
No?
Where is your document?
My lord, the application Basundhara scheme, the photograph.
Application of Basundhara scheme.
My lord, station records also do not comfort.
Okay, we are not going to vacate this order. We are disposing of this. Mr. S.H. Mahmood, learned counsel for the applicant, and also Mr. Kero, learned counsel for the respondent. Opposite party. This interlocutory application is deferred for vacation of the order dated 11/12/2024 passed by this court in CRP number 133 of 2024. It is to be noted here that by the impugn order dated so, this court was placed to stay the order injunction temporary ad interim temporary injunction order dated 2/11/2023 passed by the learned civil judge junior division number 1 Dorong Paulo in Media case number 25 of 2020. Mr. Mahmood, learned counsel for the petitioner submits that the applicant submits that the applicant as plaintiff has instituted one title suit being PS number
Lordship 42/2023.
pardon
42/2023. Title suit number, my lord. And miss case number Lordship 25/2020.
PS number 42 of 2020. For right title and interest and position over schedule A1, A10, and also for declaration that the defendants have no right title and interest over the schedule A1 to A10, and also for permanent income over the aforementioned schedule land. And along with the said title suit, the applicant herein had also filed one injunction petition upon which Mitje case number 25 of 2023. Yes. 25 of 2023 was registered. And thereafter, hearing the applicant, the learned trial court by order dated 2/11/2023 granted temporary ad interim temporary injunction. Ad interim temporary injunction. 10. Being agreed, the petitioner hearing had challenged the said order before the learned civil judge senior division. Dorong Mahol being Isabel number 14 of 2023. Trial court has granted the injunction in favor of you. In my
Injunction in favor of plaintiff.
Yes. But and against that you preferred appeal for the appellate court. Fine. Being Isabel number 14 of 2023. Thereafter, the learned appellate court, after hearing both the parties, upheld the interim order dated 11/2023 passed by the Lord Council in mistake in number 25 of the day. Being agreed, the petitioner herein approached this court by filing the civil revision petition by filing the being CRP number 133 of 2024. Wherein by order dated
11/12, my lord. 11/12.
2024, this court was placed to stay the operation of the impugned order dated 11 passed by the learned civil judge under the number 1 Parang of the in his case number 25 of the 2023. Being agreed, the petitioner, the applicant hearing referred this interlocutory application for vacating the stay order dated 11/12/2024. The Mahmoud learned conflict for the applicant submits that the both the courts below, after hearing learned counsel for the parties and also considering the facts and record and also discussing the relevant case laws of Honorable Supreme Court was pleased to grant the interim injunction in favor of the applicant. And that applicants herein have been occupying the said plot of land measuring 6 biga 1 kotha 9 lessa since for last 60 years, 50 years, and the applicants have also applied for granting land document in Bakundara under the Bakundara scheme for granting the pata, granting pata and pata of the aforementioned plot of land. And the applicant herein are residing in the said plot of land. And if the injunction order is stayed, then the petitioner, applicants herein will be evicted from the subland and they will be rendered homeless. And under such circumstances, Mr. Mahmood consented to allow this application and to vacate the order passed by this court in the passed by this court by the order dated order of this court dated 11/12/2024. Whereas par contra, Mr. K. Ahmed K. Roman learned for the respondent for opposite parties submits that the plot of land for which the title suit number was instituted belongs to the petitioner, belongs to the school of the respondent. Belongs to Puri Pukuri High School. Here, Puri Pukuri High School. And the same was allotted to the aforementioned school. And the circle officer has issued a land position certificate in favor of the respondent herein, and also one copy of Jamabandi was issued in favor of the school. And under such circumstances, the order dated 11/12/2024 passed by this court, staying the impugned order dated 2/11/2023. Impugned injunction order dated 11/2023 passed by the Lord and Civil Judge Durham required no alteration or modification at this stage. And that also is still pending before the Lord and Trial Court. And the CRP is also pending before this court. Under such circumstances, sir, the government has consented to petition. Dismiss this application. Having heard submission of Lord and Counsel for both the parties, I have carefully gone through the petition, the lesson record, and also heard the order dated 11/2023 passed with the Lord and Counsel. For 25 of 2023, and also the judgment and order dated 12/11/2023 passed by the Lord and Civil Judge in circuit number 41. It appears that while granting stay of the impugned injunction order by order dated 11/12/2024, this court has taken note of the fact that the land measuring 6 fika 1/9 letta belong to the petitioner, and that the petitioners is done under the government of Assam, and the land belongs to the school also comes under the government of Assam. And further, it has taken note of the fact that the respondents are inclusive. And they are not even tenants. Under Section 3, Certificate 17 of the Assam Certificate Temporarily Settled Area Tenancy Act 1971. And as such, granting of temporary injunction in favor of the plaintiff amount to gross miscarriage of justice, and thereafter the impugned order dated 11/20/20 was declared. Taking note of the submission of learned counsel for both the parties, and also considering the documents based on record, especially where is that Jamabandi copy? Page number? Well,
Page 33 is the certificate.
CRP or IA?
CRP, well, CRP.
Yeah. application for technology. Okay, the copy of Dhamabandi. Copy of Dhamabandi. Annexure 1 of the civil revision petition at page number 29. And also, considering the certificate issued by the circle officer, Dr. Revenue Circle, dated 5/12/2012. Annexure 2. Annexure
What is, what it, though of the technical reason it is there, but what is happening is they are, even after this